26th, but it could not be. I think Lordship has on that day Lordship could not be. So I pray for listing of this matter. Is it matter relates to dismissal from service the year 2020?
Admission matter.
Lordship, in fact, Lordship has concluded the hearing. Again, this thing.
No, is it for
Yes,
admission or hearing?
Admission.
Admission. Let's have it on 20 August.
Lordship.
Wait, please, Your Lordship, with the concern of the other side, I beg to mention item number 26. Your Lordship, 26. There is slightly inconvenience on the part of the senior counsel leading me today. He has a personal difficulty. May I pray for an adjournment for the day, Your Lordship?
26 on the request made on behalf of the council. Stands adjourned for the day.
Deeply obliged, Your Lordship.
May I present? But item number 10, my lord. Case my senior was supposed to appear in this case, my lord, but because of still started, my lord.
What happened yesterday?
Some heart problem, my lord. So my matter will be taken on 3rd of August.
Item 10 deferred on the request made on behalf of the council to the petitioners. It is listed again on 3rd.
Another fair for listing of a contempt case, my lord. And
On 3rd. Yes, yes.
with the consent of other side, I'd like to mention item number 51. I need 1 week time to file reply, lordship. They have filed affidavit.
51 on the request made on behalf of the council to the petitioner. On behalf of the petitioner stands deferred to be listed after 3 weeks, enabling them to file the rejoinder. Council for respondent is present.
Wait, please, Your Lordship. I beg to mention item number 39 and 40, Lordship. With kindly matter will be adjourned for 2 weeks, Lordship.
3940 on the request of the council to the petitioner.
Yes, Lordship.
Matter stands deferred to be listed after 2 weeks.
Wait, please, Your Lordship. I beg to mention item number 31 for admission, Your Lordship.
Item
Number 31.
31.
With the other side of council.
Item 31 stands deferred to be listed after.
It was a short date, maybe, because they had been given time, substantial time to file their objections.
Why not 2 weeks?
2 weeks.
1 week, because they've already been given 3 weeks. It's been 4 weeks.
All right. We'll give them 2 weeks and no further. 2 weeks,
Obliged.
no further.
Lordship, I beg to mention for listing of a matter for August.
Orders. 5th August. On the submissions made by the council for the petitioner, the petitioner did not wish to press the petition further, the same stand dismissed. On the roll, the order is really stand located. Ending ayes are also dismissed.
back in
Why are you withdrawing it?
SMC committee, lordship. Some subsequent development has been arised.
Subsequent?
Development has been arised.
Dismiss with liberty.
Yes.
Yes.
But the old matter, there's one case notice is not issued, another case not issued. Both the cases are almost similar.
Petition 457725, we have filed our affidavit. Reply has not been filed.
And is it?
Right.
Notice issued here.
Yes, one case not.
Oh. First one may fix for admission hearing.
WPC 4577. The respondent 350. Notice issue in 4 weeks. The petition filed the rejoinder.
I have filed. I have already filed.
Rejoinder.
Yes, so we check.
petition has already filed with you.
Second one,
That matter be listed for petition. 2 weeks. 4040, you issue, right, issue notice, return. Thus appears for secondary education.
secondary 1, 2, and 4 for the first item, big petition 4577 2024.
No, no, in the second. 4040,
Raha,
1, 2, 4, 1, 2, and 4.
1, 2, and 4.
Mr. D.K. Roy for 5, and Mrs. Moore for respondent. Extra copies will furnish to 1 week.
Already
Both
furnished
these,
earlier. Already I furnished earlier.
if not furnished, the
Soft
matters
copy.
be listed together.
Deeply obliged.
Hi, this is the matter next completion upon my lord. PLC accepted the proposal of the petitioner lord. Thereafter, lordship,
Why were you directed to file an additional affidavit?
lordship, I have submitted the detailed particulars as per notice dated 38/2025, lordship. Annexure 5, lordship, page 43, lordship.
Respondents, any instructions here?
I have not received the additional affidavit, lordship.
All right, do you get instructions in the matter?
Okay.
Respondents are permitted to obtain instructions. Matter be listed after 4 weeks. The copies of additional affidavit filed by the petitioner be served on the respondents. Released after 4 weeks.
Obliged.
Declare of against for minor. Retired in the year 2014. After my now no receive any pension.
Yes.
My lord, Inspector of School of Lordship, the Kasar, he has already submitted a pension proposal before the Director of Pension Lordship on 22/2026 with a proposal for, there's an excess drawal was there, Lordship, for waiving that amount. That proposal has already been sent to the Director of Pension. Now it is pending before the Pension Department.
Director of Pension, any instructions? You share the copy of the proposal?
Yes.
The Director of Pension, you get the
Yes.
instructions here.
Proposal. Pension.
Submitted by Mr. Chisti, Learned Council, appearing for the elementary education, that the proposal for recovery, proposal, the proposal for waiver of is what, 1 lakh?
2 lakhs.
Lakhs.
2 lakhs for 4,878.
2,04,878. Recovery proposal for the waiver of recovery of so has been sent, forwarded to the office of the Director of Pension. No instructions have been, no communication has been received from the Director of Pension. MSS and its State Council representing the Director of Pension will obtain instructions on the proposal, status of the proposal sent by the elementary education.
DO Kasar.
DEO,
District Elementary Education Officer. Kasar.
District Elementary Education. Yes, retired years for finance. Get the instructions, we place before the court within 2 weeks.
Obliged.
May I please be lordship? Matter pertains to arrears salary in the form of a provision.
area salary.
in the form of pay protection. Despite repeated official communication, the petitioner
Notice
did
has
not-
been issued here on 29/5. This has been issued in the matter on 29/5/26. Matter be listed for admission.
Manoj Kumar
MSP Das, learned counsel appearing for the secondary education will obtain instructions. And prize the court. Next date. Relist again accordingly.
Your Lordship, in this matter, Your Lordship, Inspector from Deputy Director Secondary Education has wrote down the letter, Your Lordship, to Inspector of School Hailakandi.
Do you get the
Yes, Your
updated
Lordship.
instructions?
Yes, sir. I'm deeply obliged.
Yes.
So, Lord, matter relates to correction of the date of birth of the petitioner, Lord. The date of birth, actual date of birth is 26/8/2003, Lord. And it has been recorded as 6/8/2001. All academic credentials.
You are serving where? Are you serving? You are a student.
Lord.
Are you working somewhere?
No, Lord.
Retired?
No, Lord.
Then
Can I do?
My date of birth has been wrongly recorded.
when did you notice the discrepancy?
19, Lord.
Huh?
2019, Lord.
2019. What were you doing?
I have approached the headmaster, Lord. Because the petitioner.
Yes, secondary education, school education.
My lord, I am appealing for some state school education board. My lord, the SEBA records the particulars of the candidate when the particulars provided by the headmaster at the time of appearing in the HLC exam. And he appeared in the examination in the year 2019 and applied for correction in 2025. And my lord, kindly see in his affidavit, my lord, he has mentioned that his age is 24 years. And as per our admit card, my lord, his age is 24 years.
On what basis are you saying it is incorrect?
Medical reports, Lord, as
Hmm?
well as medical records as well as the date of
Where is it reflected?
the annexure 1, Lord.
Annexure 1.
Annexure 1, the research slip of his murder.
Discharge for what purpose? For admitted for what purpose?
Delivery of child. And annexure 2 is the birth certificate, Lord. Annexure is the additional registered, Lord. And annexure 7 is the endorsement of the headmaster.
Have you approached the school authorities?
Yes. Annexure 7, Lord, page 25. The endorsement of the headmaster.
Annexure?
Annexure 7, Lord, page 25. The type copy.
No, but this is to the controller.
Endorsed by the headmaster of the school. And he admitted that the recorded date of birth was wrong.
Yes, Mr. Roy.
My lord, notice may issue, my lord, we then is that on file our affidavit.
Only for correction of date, you get instructions on this page number 25B.
Yes, ma'am.
25B, you get the instructions and tell us.
Yes, ma'am.
What steps have you taken?
Yes.
Heard counsel for party, the petition is agreed. As the respondents did not take corrective measures for corrections of date of birth as prayed for. The petitioner claims that he has approached the school concerned, namely the Lower Haflong High School, Limanasa Haflong, requesting for correction of his date of birth. And the school authorities in the meantime, on the basis of his application, has already forwarded communication dated the date.
My lord, the copy provided to us not legible at all, ma'am. Here, my lord, date is also not mentioned.
By communication. There is no date, there is no number. What is this?
Lordship date. Not there.
Huh? You get a legible copy. You show us the original here.
Yes.
I have to collect it from my.
Collect it and show it to us. So how will they give any? How will they docket this document? There is no number. There is no date.
Yes, Lord.
Then how was it sent? You get it. When can you get it? Next week. Mr. M.K. Bora, Mr. M.K. Bora, please, 2 days time to take further instructions from his client regarding the communications issued by the school, concerned school to the controller of examinations. It's this matter again. If
By way of excellence.
we don't know, you get it. Whenever we want to see whether it is there, not there, then we decide.
Like.
The D.K. Roy appears for the school education.
My lord, Rashtrapati was supposed to order. Issue is almost similar, but the factual aspect is little different one. Presently, the issue is before the secretary. As per the proposal, here I have enacted in page number 90.
Sure. Give her a copy. Give her a copy. Go through it and tell us. Can be closed in terms of this order. We call up after the way.
The lordship, the petitioner by the way of this proceed challenge.
The recorded lot, before lot takes the matter, we filed an affidavit yesterday. Probably it has not yet come to the record.
It is not.
My request is that your lordship, it's already 29th of July. May the matter be taken after lunch? It will come on call.
The lunch will be difficult, it may be taken up tomorrow or day after tomorrow.
It's difficult for me to come from Delhi, your lordship. Although I can appear online, but physical appearance needs a different impact. Maybe my copy may be taken on the call. Just
You
for
call
the
for the affidavit. We'll take it up at 2.
of my lordship.
Okay.
Yes.
My lord, we are at the CK College, Chakla, in the district of Bongaigaon, madam.
Right. Yes.
In the tenure of the earlier MLA, there was a meeting of the DMFT under the chairmanship of District Commissioner Bongaigaon. There, in the name of Chakla College, a grant of
Some
rupees
fund has been issued that is not released.
that is not released.
Released by whom? Who is
Released
supposed to release it?
by the DC.
DC? Who's appearing for DC? Why have you not released the fund?
And in the meanwhile, new MLA has diverted the fund to another school. Our school is, well, our college is established in the year 2000, having arts and commerce section. And the school to where it is sought to be shifted, that was established in the year 1945 with all facilities are there. In 1945, that has been provincialized.
Why you get instructions?
So we are not against them, but our fund should be released. Because earlier it was granted, foundation stone was also laid down.
You want us to issue notice?
Lordship, I issue notice.
Until then, may not.
Till then what?
And our fund may not be diverted to hand.
We don't know whether any fund is there or not. That's the instructions we wanted to
Fund
find
is
out.
there, that was already allotted by law. Kindly
What-
see page 44.
Where are the documents to that effect?
No, kindly see page 45. Here, conference hall, District Commissioner's Office, Bongaigaon, 2011-726. Operative portion, Lordship may kindly see page 46. Here, first, my lord, the present MLA Nurul Islam, he has transferred the fund. Infrastructure development of Chakla High Secondary School. Now, this is 25 lakhs. Whereas, our school was given that fund on 3/1/26, kindly see page 17. Right? Page 17, bottom. Construction of additional classroom and infrastructure development of CK College Chakla. So this is earlier one. So earlier one, it was also held under the chairmanship of the District Commissioner Bongaigaon along with all MLAs and other members of the committee. So we also filed a representation before the District Commissioner that kindly release the fund because our college is not yet provincialized. But they are not giving us.
No, on what basis are you saying that the funds for the CK college and the high secondary school
Yes.
are one and the same?
No, not one of the same, totally separate establishment. CK,
No, we are not saying,
Sir.
we understand their separate establishments. Your grievance is that the fund which was allotted to the college
yes,
has been transferred to the school,
sought to be tested.
sought to be transferred.
Right.
On what basis are you saying that?
Because there's the proposal by the next MLA.
That proposal has no indication that it is connected to the earlier proposal.
That is not, yes, that is true, but
Then
actually, expressly they have not done this, but impliedly, my lord, as the fund has been not released to our college, which was granted earlier, now again to another.
have you approached the DC's office?
Yes, ma'am.
Where are your representations?
Yes, ma'am. The Lordship may kindly see page 42. So, my lord, this representation remain unattended. In the meanwhile, that fund has sought to be transferred by the new MLA. There is rivalry between the earlier MLA and present MLA. So, due to their rivalry, our venture college is suffering. So, my lord, till our fund is released, the fund allotted to Chakla High Secondary School may not be provided to them. Because we are earlier one. We have a
Unless we know that the funds are, these are the same lot of fund.
then, my lord, until further
Let them get instructions,
Lordship,
to obtain instructions.
One-
but no further action may can be taken.
That we can't give you right now. We are not issuing notice, you get instructions, what has happened to the development, the fund allotted to the college.
Okay.
If you can't get instructions, we may be constrained to pass interim orders. Third counsel for parties, the results of the report that the fund which was allotted to CK College Chakla by
UMFT, Bongai,
by what?
UMFT,
District Mineral,
District
District
Mineral Fund Trust.
Mineral Fund Trust.
Fund Trust Fund for the
Showing an amount of 36 lakhs for construction of additional grass infrastructure for development of CK College Chakla. So, it is the grievance of the petitioner that this amount has been sought to be transferred to the high secondary school by the MLA,
newly elected.
newly elected MLA of the concerned constituency, concerned area. So, it is submitted that the fund which was already earmarked and shown to be allotted for the CK College could not have been diverted by the authorities without following the proper procedure. So therefore, the petitioners are before the court seeking a direction for release of the fund already allotted to CK College. So petitioner 1 and 3 are the members of construction committee of CK College Chakla, and petitioner number 2 is the principal and president of the construction committee. The MSS form, then State Council will obtain instructions as to whether any fund has been indeed earmarked for Chakla College. And if so, whether the amount has now been sought to be diverted for other purposes. This information, this instruction be placed before the court by the next date, telling which the court may proceed to pass appropriate orders.
Short date mechanism.
Released again on 7th
Lordship,
7/8.
August. The petitioner will furnish sufficient extra copies to the respondent counsel. By today,
Yes.
within 2 working days.
Yeah. Per High Court order, my lord, or actually we are under NPS, my lord, National Pension Scheme, awarded to old pension scheme, my lord, and now entitled to be a year salary twice pay fixed. My lord. Already proposal has been sent, my lord, the annexure 8 medicine, my lord.
Which department? Elementary.
Education.
Who's for elementary?
yes, Lordship,
You're appearing?
Lordship,
There's one hearing for the respondent. For respondent 1,
123, Lordship.
will obtain instruction as to status of the claim for the petition for release of the revised and for release of areas quantified on the revised pay structure. So the notation, the extra copy. Release this matter again. 14th
Item 14 also similar.
item,
14,
14,
14, 1, 4.
1, 4. This is item number
Item number 11, this is
11 and 14 similar orders. It's 14.
Reading my lord, the matter pertains to provincialization of the services, my lord. This is in fact not third round of litigation.
Herein we are challenging a recommendation, my lord, passed by the district level scrutiny committee, that is in pursuance to an order, my lord, passed by this honorable court. Wherein, my lord, that the impugned, my lord, the provincialization order of the private respondent was, my lord, set aside by this honorable court. And my lord, my lord, earlier we have the petitioner preferred in appeal, my lord. Then the my lord, secretary to the school educations has rejected my claim in the appeal, my lord, giving an observation that the my lord, headmaster, so my lord, the headmaster of a school is to be considered as a social science teacher, irrespective of the fact, my lord, the which subjects he taught. So, my lord, considering those aspects, my claim was, my lord, rejected. Even though, my lord, I am not claiming as a social science teacher, my lord, I am claiming as a language teacher, being senior, my lord, I am claiming my lord,
Yes,
provincialization.
obtain instruction.
My lord, hearing this,
Notice may go.
no, my lord,
Private respondent is there.
no, my lord, here on the prima facie, my lord, may I just draw your lordship's kind attention as regards to the, my lord, order passing the appeal. My honorable court has given them my direction. In spite of the giving the direction, my lord, wherein that, my lord, increased provincialization is, my lord, that has been, my lord, set aside. Now, my lord, the phase consideration after communication of the order of this honorable court, they are not giving any reason, my lord.
Right, regulation notice.
No, my lord, kindly this order may be stated, my lord. The prima facie, my lord, prima facie, it's a, my lord, arbitrary exercise. Just for a moment, my lord, just for a moment, with all due respect, my lord. Because otherwise, my lord, I will suffer irreparable loss, my lord.
Elementary education.
Lordship, just kindly for a moment, my lord. With all due respect, my lord.
Yes, we are hearing you.
It's my lord, excessive exercise of my lord, colorful exercise of power.
6 being represented. Respondent 7. Speak. Which letter you want?
My lord, 57. That is the impugn order, my lord.
57.
57, my lord. 57 impugn, and my lord, the honorable court has, my lord, already set aside its provincialization on the last para, my lord. On the last para, as per my lord, so and so, Gauhati decided that as per the rule so and so, the educational institution amendment, the service of the incumbent answer category institutions were made provincialization. 3 teachers, science and maths, social, 1 language. Sri Prafullo Kalita was not considered and not recommended as assistant teacher social science, also tutor. Well, I am not claiming as a social science teacher, I am claiming as a language teacher. And thereafter, my lord, in the place of Surya Bothakur as headmaster is eligible to teach social studies, English, Assamese. So, my lord, he is the headmaster of the erstwhile, my lord, Hansar school. He has not been, my lord.
You are claiming provincialization in which subject?
My lord, Assamese, my lord.
Assamese.
Assamese. I am the senior most.
Surya Bothakur
is English, man.
English.
Yes, man.
Who is provincialized in Assamese?
My lord, Assamese, my service was not provincialized.
Not provincial.
And my lord,
who is there anybody who is provincialized?
yes, my lord, Surya Bothakur is provincialized.
But in English, not in Assamese.
My lord, English, my lord, as per section 3111, one of my lord, may I just for a moment, my lord, refer to section 3111 of this act, my lord. 3111 says, my lord. 3111, in case.
You are praying for a stay of his provincialization.
My lord, provincialized of, yes, my lord, and this, my lord.
You will have to issue notice.
My lord, not his, my lord, for the time being, I am only, my lord, praying to stay the operation of this impugn order.
Operation of this order will affect the private respondent.
Yes. Well, private, definitely, my lord.
So you'll have to issue notice, go and take dusty service on him.
No, my lord. What I am trying to substantiate is that, my lord, already honorable court, which is Satrando Division, has said, sir.
We'll examine that.
Yes, and my lord.
You have arrayed him as a party.
Yes, man.
Now, without giving him notice, you want a stay of an order which is going to affect him.
My lord, this order has been, my lord, passed with, my lord, violating all the, my lord, rules, regulations of relevant. It is prima facie, my lord, it is arbitrary. Because
no, it's not arbitrary prima facie.
Prima facie arbitrary.
No, it is not. Because you are not serving copies on the private respondent. You should have given him an advance copy. That I am going to file a writ petition. This is an advance copy. Appear in the matter.
I am not, my lord. Only this order is, my lord, prima facie arbitrary. That's why, my lord, I am approaching before this honorable court.
This order will have an effect on the provincialization of the private respondent.
Yes, my lord.
Then,
that's why, my lord,
without hearing him, Where is this?
No, I am
question
not,
of stay?
my lord, saying before your lordships to stay his provincialization.
Uh.
The operation of this impugn order
That is the same thing.
shall be stayed.
No, you are not going the left way, but you are coming the right way. It leads to the same
No, my lord.
destination.
Once it is arbitrary. They
We'll issue notice here.
always a
Issue
arbitrary.
notice on your state rate.
The prima facie, my lord, just for a moment, I would like to, my lord, make my.
We have heard you.
No, no.
Issue notice on the interim rate. Returnable on 12th day. Steps on respondent so by speed.
My lordship, I kindly given an observation that, my lord, provincialization of the service of the respondent number 7 is, my lord,
If you
subject
want
to.
it, then we are withdrawing the order issuing notice on the state rate.
No, my lord. It's okay.
You can't get both.
No, my lord. I'm
Either
only,
we issue notice.
no, my lord, I'm only
Either
saying,
we issue notice on the state rate,
Yes.
or we say that the provincialization of private respondent is subject to the outcome of the writ petition. Which one do you want?
my lord, then lordship may fix the sorted. I will take justice, my lord.
Yes, service on dusty service on respondent, private respondent is also permitted. Released on 21st August.
Obliged.
This case, my lord, we have challenged the service rule, my lord. So I.
You're challenging
The service rule, my lord.
service rule.
Yes,
You go before division bench.
yes.
Where is the prayer?
Page 55.
59.
55.
55. What is the notification? 18.2.
This is the, my lord, impugn service rule,
Amended.
amended rule. Assam Elementary Education Provincialization amended.
Page number.
Page number.
Page 147.
When you submitted that challenge is made to the amendment brought in by the state by notification dated 18/2/2026. And the challenge in the writ petition, the prayer in the writ petition is seeking a direction to amend certain provisions brought in by notification dated 18 February 2026. So by the same notification, the Assam Elementary Education within bracket provincialization rules 1977 is amended. Considering the above, registry will take steps to place the matter before the appropriate bench as challenge is made to the rules or amended rules are to be heard by division bench as per notification issued by the registry. Ordered accordingly.
Okay, thank you, man.
You go and approach the registry then.
Friends.
Please, your lordship, this matter pertains to area salary in the form of MSCP upgradation and grade pay enhancement. The total amount is 81,953. But kindly receive page number 5. There are 2. May I read, madam? That the petitioner begs to state that she joined service on.
This will only be subject to instructions coming.
Lordship.
Get instructions without issuing notice. Get your instructions. Can you do it?
My lord,
Hmm.
item 15
to 18, all matter similar.
Oh, yes.
School is same, school is same.
Third council for parties, the petition is agreed. And it's prayed for payment of the grade pay enhancement by the respondents. MS and Sharma appears for Department of Education, 3 and 4. And Hazarika for respondent. Respondents will endeavor to obtain their instructions in the matter as to the claims made by the petitioner for release of grade pay enhancements. Release these matters again on 21st of August,
31st.
21st, by which date respondents will apprise with respect to the status of the claims made by the petitioner. This is a petition, extra copies will be furnished in 2 working days to the respondents to obtain the required instructions. Which are the items?
15 to 18.
15 to 18.
Yes, madam.
15 to 18, list on 21st August.
Highly obliged.
Original file is by senior son is unattended. So
You are praying for an adjournment.
that's
The request made by the council, it stands deferred to be listed next week.
Only thing that Lordship SC aggregate is not a party in this.
We don't know, let it come. Yes.
Petition and hearing on the accommodated tutors, they are appointed in 2000. But effective come from 1/11 to 2020. It's 1 November 2020. They are entitled to receive some money. They are seeking area salary.
Area salary.
Area salary.
Third council for party, issue notice written. Mr. SMT Chisti appears
1, 2, 4, and 5.
1, 2, 4, and 5. MS Hazarika appears for respondent number 3 and 3 and 6. Since the respondents are represented, waive extra copy condition within a period of 1 week. Respondents will complete their instructions and file necessary affidavit if so like.
No, the pendency may not be one.
Pendency may not be a bar to redress the grievances of the writ petition.
But
Pass over for time being.
Hmm?
Pass over for time being.
Passover, right?
My senior is a court number 18.
Passover. Passover.
First of
Hey, please, your lordship. Lordship, the petitioner here, she is a regular SRD teacher. My lord would recall, my lord, on the last Tuesday and even yesterday, my lord be hearing that regularization issue. Here, my lord, the petitioner was regularized. After she had approached the court, she had approached the regularization under the department, and she has been regularized. The order is at page 61, annexure 9.
Yes.
So after her being regularized, my lord, she was made as head teacher in charge of the school.
This is not regularization.
My lord, the regulation order is that My lord, at page 60, sorry. But the type copy is at page 50. It's at page 56. 55, the part is effective part. The in exercise of the power conferred upon the DE, Assam by the government letter so and so, my lord may see, and district subject of final outcome the WPC 40214 and other writ petition subject matter of regulation and necessary issue pending in the Honorable Gauhati High Court. The appointment is purely and is liable to be terminated without assigning if any fraudulence regarding the credentials submitted by the appointee is established by the appointing authority at any point of time in future. Then, my lord, the appointee concerned, next page. The appointee will join his respective place of posting only after successful verification of original testimonies at block level under the supervision of concerned district commissioner. The appointee is issued against the personal post created by government letter number so and so and approved received from government via number so and so for the special recruitment drive under the Director of Elementary Education Assam to absorb the SSA contractual and state pool teacher. As the post is personal in nature, it will get abolished as and when the concerned superannuates. The appointee concerned will get basic salary with admissible allowance and the first increment be given only after 1 year of satisfactory service. No claim of any pecuniary benefits of past work will be accepted. No PF support of any kind shall be admissible. Start new pension scheme. Contribution only shall be provided. At no stage, claim of old pension scheme from this post shall be considered.
Then
Thereafter, my lord, she was being the most senior most teacher. She was made head teacher in charge. That is at page 61, man.
yes.
That for the full functioning of the school on the basis of proposal so and so, is hereby allowed to hold head teacher in charge of the same school with financial transaction. Now, my lord, while she was functioning as an SOP was issued, this SOP, as per this SOP, the earlier orders was issued. That is at page 66, annexure 11.
Yes.
My lord, at five serial number, my lord. Interim head teacher arrangement. The DEO, District Inspector of School, DIS, will appoint an in-charge head teacher in the school in lack of regular head teacher. So, and if school has no regular head teacher, the SRT appointed is the senior most. They will be upgraded to the post of head teacher and the previous position will be automatically abolished. I, being the senior most teacher, I was put as head teacher in charge as there was no head teacher available at that time. And because this issue was pending before the court also. My lord, thereafter, my lord, in a similar case, 3685 of 2025, where contractual teachers who were head teacher in charge were passed order to be removed from head teacher, where the Honorable Court, after hearing, had passed an interim order saying that status quo will be maintained. My lord, the judgment starts at page 68, annexure 12, and at para 14 is the projection made. And the issue in question, my lord, and the observation of the court, as is at para 9. So status quo was given. Thereafter, my lord, I gave a representation on 4th April 2025, where I prayed that I should be continued as a head teacher, and they had given me, accordingly, they had abided by my representation. However, while this matter and everything was pending and it's been before this Honorable Court, they passed an order where now another teacher whose has been replaced by me and has been asked to replace, and that person is going to be head teacher in charge. So, my lord, the purely question of law is this: how can a temporary arrangement can be replaced by another temporary? I, being the senior most teacher, as per the
Where is that order?
that is at page 77, annexure 14.
Okay. What is the proposal inquiry report?
There's nothing. I have been furnished with nothing, my lord. Without they had held inquiry behind my back. They did some, and then thereafter they come up with this, and I was not, and there was no fire. There was absolutely no fair hearing. Nothing happened. I've given a statement with that regard. And the statement
This
is
order was passed when?
it was passed on 6/7 during the vacation, my lord.
So who's holding charge now?
I am holding charge, my lord.
How? in
Because-
view of this order?
Because the school has not opened till yet. The school will open on 3rd of August. Because of the vacation. So
But-
I am just asking for the status quo and stay, because my lord, similar orders, similar issues has been
No, but
pending.
where is the assurance that the private respondent does not join?
My lord, private
In view of this order, they have joined.
no, my lord, because the school has to open on 3rd of August, then only the joining will happen.
Yeah, what do you say?
Well, I'll take instruction. Probably, my lord, he may join in the block, my lord. Otherwise, in the deputy inspector. Regarding this, I'll take instruction, and my lord, notice may go, private respondent is there, my lord.
So my lord, at least till then, let status quo be there.
But Mr. S.P. Sharma, Mr.
Respondent number 1 to 4, my lord.
Respondent 1, 3, 4. No problem notices will be issued. Respondent 1, 3, 4. I will expect copy will be furnished within a period of 3 working days. Petitioner claims to have been appointed. By which order were you appointed?
That is at page
55.
28 is my temporary order, and after that I was regularized on 22nd September 2024. Page 60.
Regularized our services by order dated 2nd of September 2024. As assistant teacher in rural primary school. Thereafter, terms of the petitioner is given the responsibility of in charge head teacher by order dated 15/10/2024. As she was the senior most teacher at the relevant point in time. Council petition is referred to SOP, which provides for upgrading senior most assistant teachers to head teachers in lower primary schools, where it's provided that slash deputy inspector of school will appoint an in charge head teacher in the school where there is no regular head teacher. Stop. And if the school has no regular head teacher, the SRD appointed teacher, senior most, then they will be upgraded to the post of head teacher, and their previous position will be automatically abolished. So we submitted that, notwithstanding this SOP, the respondent department has issued the impugned order dated 6/7/2026, whereby the petitioner has been replaced by the private respondent, and he's been given the responsibility to hold charge of the in charge headmaster of the same school with financial transactions. So he submitted that as on date, the petitioner is still holding charge and is not given charge to the private respondent. So the rebuttal of the petitioner is that the respondents have not followed the SOP issued by them, and petitioner being the senior most was required to be given the responsibility of the charge head teacher, which was granted by the earlier order, but for reasons best known, the same is sought to be recalled, and the private respondent has been sought to be given the responsibility. Mr. Bora submits that he has no instructions in the matter and be permitted to complete instructions. Considering the above, let this issue returning. Since Mr. Bora represents respondent 1, 2, 3, 4, since the main Mr. Bora. steps on responding, five speed in one vehicle. You should notice on the interim prayer, we can able on 14th August.
Or till then status quo may be
It is
similar. cases.
submitted by the court. So that is date. Give the ensuings to the holidays. Petitioner has not on the card. Therefore, will be permitted to make charge to the next submissions made. Status will be maintained the next return of the day, which is 14/6, 14/8/2026.
Where this, my lord, the other issue, other cases, my lord has fixed on 13th. On 13th, on
The
last
other
week.
cases are on something else.
It's
How are
the-
these,
my-
how are these relevant?
Because
How
my
is
lord,
this relevant?
if the regularization and this prospect of SOP is set aside there, then I automatically, we will,
Then whatever orders will follow,
my lord. My lord, for, it doesn't seem, as my lord.
Yes.
Here, basically, I'm exceeded by the non-action of the Bar Council of India. What has happened? I run a law college, a degree course, BA LLB. And every year, I mean, I have a regular affiliation with the Bar Council of India. They give the approval. And then in the month of December, as required, I paid my fees as well as the extension application that was done done on the 3rd of January. My payment of my fees is at page 38 and 39. 3 lakhs for the course fee, that is for extension of approval, and 50 lakhs, 50,000, which I have to pay for applying for extension. Lots of this was done. I took out a printout and I found that my application has been submitted because Bar Council has changed the system. Now we cannot submit our applications through hard copy. We have to do it on the portal since 2023. I submitted that. Thereafter, Lordship, sometime in May, I get a letter from the Bar Council, which is a very general letter you issue to everyone. Lordship, which says it's an annexure 4, Lordship, page 40, will find Lordship. It is hereby informed that certain deficiencies have been observed in the extension of approval application submitted by the Center of Legal Education, that's us. The deficiency may include non-submission of the academic council resolution, non-uploading of the permanent temporary university affiliation, order of the academic year 2027, or failure to submit the extension application for the academic year this and this to the designated portal. In this regard, you're instructed to revisit the portal and verify. So when we revisit the portal, what we find, Lordship, a fine of 4 lakhs has been imposed. That's at page 5. A fine of 4 lakh has been imposed. Page 42, annexure 5. Now we have, and then we write to Bar Council again on immediately thereafter on 22/5/2026 that we have submitted our extension application. We paid the fees. How is this 4 lakhs coming? There's no response, absolutely no response for them. We gave all the documents and closed everything. Lordship will find it annexure 6, page 43. We submitted everything to the secretary. They do not respond. Thereafter, Lordship, on 13/7/2026, that is at annexure 7, page 49, a general letter is issued by the Bar Council of India to the vice chancellors, registrars, deans, principals, directors, all universities, existing centers of legal education, imparting legal education, and for giving the final opportunity for all existing centers to submit and complete the application on or before 31/7/2026. Now, my problem is that if I go to the portal, I have to pay the late fee, only then I can submit. I have written to Bar Council has not responded. Lordship will come to page 7, page 45, Lordship, at clause 8 is important. When an institution claims that its application has been completed, but the portal continues to reflect an incomplete or pending status, it shall communicate the issue to the Legal Education Department of the Bar Council of India on or before 37, together with the CLE code, application number, payment particulars, proof of final submissions, and relevant screenshots on supporting documents. Lordship, we have done this. We did this on 27, again, 27, 2026. Even then, we have not received any response till today, so we are forced to come because there is a very drastic clause here. That's at page 47, which says a center of legal education which fails to submit the requisite application within the prescribed period shall not be entitled to claim continuance of renewal of approval or undertake admission for the relevant academic session in absence of the valid approval or provisional approval issued by the Bar Council of India. The concerned institution or university shall be responsible for all the consequences arising from such non-compliance, including any prejudice caused to the students. So now, Lordship, I can't take in. My students will not be able to do exams. I have done everything. Now I can't approach the portal because the portal says you pay 4 lakhs. Why will I pay 4 lakhs? I am not a rich college, affluent college, Lordship. I run from hand to mouth. I have to take care of the thing. Now 31st is today, is already the 29th. So unless Bar Council responds, and the payment they know, Lordship, it's there. Payment has been made. It was made in January itself. And by Annexure 9, even the payment clause has been extended up to March. So we
So what prayers do you have? Do you want?
I have a prayer that to allow me to induct new applications because the academic session will begin now. And Lordship, and not to force me. That is the prayer I have. Because rest the Bar Council will look. At least I hope. Set aside that 13.7 letter and the imposition of late fee of 4 lakhs. This is one of my
That will be subject to the instructions coming, information coming from
But right
Bar
now,
Council.
I may be allowed to take new admissions, not because admission sessions have started.
No, is there any restraint that you cannot take it?
They have said, Lordship, I cannot make as per the 13th letter.
Where is that?
13.7 letter, that is at page 49, Annexure 7. No, page 44, Annexure 7. Lordship will find at page 47, an application submitted after 37 shall not be entertained, save pursuant to a specific decision of the competent authority Bar Council of India, except in duly substantiated circumstances. No institution shall have any right to claim such for extension. A center for education which fails to submit the requisite application within the prescribed time shall not be entitled to claim continuance of renewal or undertake admission. Now, as per their records, I have faith because they show pending and a 4 lakhs fine has been imposed.
See, giving you permission to take
Admission.
induct new students admission is only strength of the court's order.
Yes.
Later, if it is found that yes, there are some provisions under which was not known or brought to your notice, or whatever, your registration could not be extended. What happens to the student?
Lordship, then they can go to a nearby college. That provision is there. But Lordship, my revocation cannot be done without giving me a hearing.
No, quite right, quite right.
So I can
Because-
satisfy. I
Right.
can satisfy because I have been operating my college from 65.
You have to, can you show us the provision? Under which the process for cancellation of your,
Yes, Lordship, it's under the legal education rules. I have, in fact, I have,
is it available under the BCI rules?
no, Lordship. I've downloaded from the internet, Lordship, and I have copied it also. And it's at page 10. I have just copied it to page 10 of my presentation. Revocation. Bar Council of India may revoke the grant of a temporary or regular approval if the condition on which the permission was granted was not substantially fulfilled. A regular permission may be cancelled on adverse report of inspection. Now, inspection has not happened. It will happen only now. Provided in case of revocation of a temporary or regular approval, the Center of Legal Education Authority and the respective university shall be provided with an opportunity of hearing and rectifying the shortcomings which such time as the education committee may prescribe. In the event of the failure to rectify the shortcomings in the opinion of the legal education committee within the stipulated time, the education committee shall recommend recommendation of the approval to the bar council. This is the provision. So there's a provision which provides me. Provided further that in case of revocation or cancellation of approval, as the case may be, proper provisions have been made for the student.
So as on date, your revocation has not happened. Or
Revocation is not.
there's no notice.
There's no notice.
So,
But it may happen if I fail, because the 13th letter says.
no, so why do you want a protection from the court? To
Not
go
sure.
ahead for admission. You go ahead because there's no restraint.
No, this letter, 13th letter, is really a little scary, Lordship, for the institution. And Lordship, we are answerable to the students also. We are answerable to the students also.
As also the court.
As also the court.
So therefore, as on date, there is no restraint.
There's no restraint, but
So
they
you
say.
can go ahead for admissions. Yes, there is a restraint and which you think has come without giving you an opportunity, definitely court will step in.
But that time may be too late, Lordship.
But as on date, you are an existing institution. Your approval has not been withdrawn or recalled or anything.
No.
There is some issue with regard to depositing the fee within a specified time, etc. You apprehend
Yes.
that in view of the no communications coming from the authority concerned,
Yes.
some adverse action may be taken.
Yes.
That will ensure that will direct that no step be taken without giving you a sufficient opportunity.
And Lordship, 26, 27, they've not given me the approval. So how can I take admission?
That's what we are asking you. Is the approval required to be cancelled, or is it a case that fresh approval not granted will be deemed to be approval cancelled?
It shouldn't be, but I need the approval for admission. Lordship, because they do not act promptly. That is the problem. That's what they have been
So
facing.
is there any counsel appearing for Baka?
In for Bar Council India now. For Assam.
Oh, not Assam.
In Honto, we have served copy. I don't know whether it's because name is also reflected.
P-bond. If he appears, then we should hear him and ask him what steps. You can ask your colleague, find him and give him the information, we'll call it up again. Considering the fact that there's hardly any time for you,
Absolutely, Lordship. That is why.
that's the reason.
Because tomorrow, if the question arises, why did you not come before your at least application was submitted, and that matter is sorted out.
You request your colleague to find him out and inform the court master, will call it up immediately.
Absolutely.
May it be pleases your lordship. Here, your lordship, as per rules, your lordship, the only thing is that he has exceeded 57 years as on 1st January of the year of the requirement. However, petitioner have already crossed the prescribed upper age limit of
No,
50.
we have
Seven
left it to the department
Yes.
side in case you take a policy decision.
And
then giving
it is
the benefit.
formal request to look into the matter and issue.
Is it all right?
Under
Ultimately,
consideration.
they would file a representation that government will decide. Lordship.
Decide.
That was the direction.
The direction is that if the department undertakes any exercise or condonation, subject to the response to the memorandum submitted by the Samstha, and if any order is passed for relaxation, then the benefit should be granted to the request. That's it.
And Lordship here, Lordship may kindly specifically direct the petitioner to file a representation.
Have you also filed a representation?
Some of the file manner. Fine. So let them file it individually, Lordship. Yes. Because individually.
No, but what is the difficulty here? We can add one more line that in case the decision is taken by the government on that representation of the Samstha, giving the benefit, then petitioner and other similarly situated candidates' cases will be examined on a individual basis.
Individually.
That we can add.
Yes.
Yes. Heard this too. Last one at the line over.
But the factual aspects are different one. It will be taken from
Therefore, we say that it
Yes.
shall be individually explained. There's otherwise no point in asking all of you to file representations seeking similar orders here. The Sanstha has already represented the teachers. So that is still pending, isn't it?
But that is a factual fact that will be a difficult.
Actually, you examine and say whether it is covered or not. Therefore, we are giving liberty for examining it factually.
Yes.
Individually.
Yes, factually. Individually.
Last one, I know very well. After due verification of the individual cases of each of the teachers, and the said benefit be extended only if upon making such verification.
One thing, my lord, as the my lord process of selection has been initiated and the process of consideration of relaxation is pending. So, my lord, it will be completed prior to completion of the selection process. That
No, but the Sanstha is not before the court.
yes,
Sanstha
Yes,
direction
yes.
is already, they have already filed. We have only said that if you take any decision in favor of the members of the Sanstha, similar benefit should be conferred. There is no direction to dispose of the Sanstha representation in a fixed time.
yes, yes. But we have also individually submitted representations, my lord. So
That is what we don't want to do. There is no point in flooding the officers with representations.
yes. So, my lord, this may be considered prior to completion. Otherwise, my lord, infractions. So this is
Endeavor shall be made by the department to examine the claims of the persons concerned prior to the completion of the
selection
exercise undertaken to fill up the post of
principal
of high secondary
high
schools.
secondary.
It should have come earlier, Lordship.
This post. Yes.
We completed, my lord,
You mentioned it on the ground that
Yes,
your
my lord,
senior was not there.
my senior is code number 18.
Yes, Mr.
Possible issue noting when person to injury protection, they have completed their internship now. Now they want that they should get the final course completion certificate. That my lord will be subject to outcome of the litigation.
Lordship
First
already
litigation, which is
already
pending.
completed, my lord, the mandatory 1 year's internship, my lord, and my lord, on we supposed to
Page
Lordship-
44, lordship will see, my lord. Page 40.
Lordship, Lordship, tomorrow is the last date for
Last date
All
for-
India, my lord, All India Ayush postgraduate entrance test, my lord. And the authority already, my lord.
Tomorrow is the last day. Why have you come today?
Lordship,
Why have you come today?
so, there is no date, my lord. On 14/7/2026, my lord, we completed our 1 year internship, my lord. And authority, my lord, already issued no objection and no liability
They have
certificate, my
completed
lord.
this internship.
Yes,
Yes, there was the interim protection given, man. So why don't you issue the certificates?
Lordship, Annexure 16 may be seen, my
Well, the
lord.
issue, my lord, initially, my lord, their 4th year, my lord, entire exam was cancelled. They took a, my lord, interim protection and they were allowed to continue with the internship. Now that part has been completed, but the main issue is yet to be decided by the honorable. It is pending regarding the cancellation of the entire 4th year. They are also petitioners here. Yes,
Yes,
he is
my
the
lord.
petitioner, main petitioner. That's why I was
Lordship,
placing at page 44.
when my lord interim was granted, my lord, this honorable court, my lord, observed that there was no fault of the petitioners. My lord. In
That is the prima
page
facie
number
finding.
47, my lord, the paragraph 4 may be seen. This is the interim one. Hereafter, my lord, we
Then you
completed our.
you should file the die anyway. Heard counsel for parties. When is this matter fixed? Why not
It's not fixed, my lord. Lost 1 year,
The
my lord.
petitioner is before the court being agreed that the mandatory internship required to be undertaken by the petitioners having been completed. The completion certificates have not been issued. And as a consequence thereof, the petitioners are unable to apply for their what master degree?
Yes, my lord, postgraduate
Postgraduate
entrance.
entrance. Scheduled to be held when?
Tomorrow.
Tomorrow.
Tomorrow, my lord. Last date of filing the.
Scheduled for which the last date of filing the application is the petitioners have also filed WPC 2722 of 26, where
We lost 1 year, my lord, with allowed.
where the notification has been put to challenge, which provided that they have to appear in the 4th PHMS examination where it was provided that 6 months mandatory period is required to be maintained between the 3rd and the 4th PHMS examinations. So the school, while issuing notice, permitted the petitioners to sit in the examination. 2026. Now you have passed this examination.
Yes, my lord.
Well,
already passed, my
examination passed. Thereafter, well, there is a period of for 6 months or 1 year. There is a period for internship. There also they have completed. So they won the internship completion certificate. They are paying in the interim that a provisional internship completion certificate is issued. At least they can apply for the internship.
Yes, my lord. That
That is the prayer. That will do it.
Provisional-
Lords will make it
That
subject
may
to
be, my
outcome
lord.
in that case.
that may be.
Since the petitioners under the orders of the court by the order dated 25/5/2026 had already appeared for the 4th semester examination, and in the meantime has also undertaken the compulsory internship, undergone the compulsory internship required. The petitioners have sought for filing their applications for appearing in the postgraduate
entrance test.
entrance examination scheduled to be held for the homeopathy. What is the term, Paul? Postgraduate degree in homeopathy. For which the postgraduate degree, postgraduate studies for acquiring the MD/MS programs in homeopathy, which they could not apply, which they would not be able to apply unless the internship completion certificate
And college pass certificate. College pass certificate.
college pass certificate and internship completion certificate are issued. Stop. Considering the urgency expressed, and also upon taking into consideration the submissions made by Mr. state that the core issue of whether the application mandating the maintenance of compulsory gap of 6 months between 2 semesters, which is being essayed in the present, essayed in WPC number 722 of 2026, which is presently pending in school. That
Page 19 is the interim clearance.
that the internships completion, provisional internship completion certificates, and also the provisional provisional certificates regarding the completion of the semester exams can be provided to the writ petitioners, enabling them apply for the postgraduate courses in MD/MS homeopathy. So, however, it is made clear that the final certificates will only be issued subject to the outcome of the present writ petition,
As well as the
also-
already pending case.
as also WPC number so and so. So, totally, get this writ petition be also connected to WPC number so and so and be listed after which the respondents will forthwith issue the provisional certificates as directed to the petitioners, enabling them to make necessary applications for pursuing their postgraduate MD/MS in homeopathy.
They are only praying for issuance of the provisional internship completion certificate, not the school college leaving certificate.
College leaving certificate. Some other.
Give them the certificate if it
Yes,
is
sir,
necessary.
required if necessary.
Extra copies be furnished within the course of the day. Please furnish extra copies within the course of the day.
Well,
Petitioners have been
After 2 weeks. Along with WPC. Yes.
petitioners before the Lordship are the teaching and non-teaching staff of the high school under this heading. There is a writ petition pending before this honorable court, page 19 Lordship, where this honorable court in the interim states the shifting of the school.
Also. Yes.
Page 19 Lordship, a writ petition is pending before this honorable court regarding the shifting of the school. There is the interim order in favor of the earlier place of the schools. Now what happened, Lordship, the school inspector at headmaster Lordship deleted the name of the petitioners from the Shiksha Setu portal, Lordship. That's why they are
Get your instruction.
Lordship.
Then
And
can you get it?
their salary also stopped.
In that manner, Lordship, I am permitted 10 days of time, Lordship.
When is it fixed?
On
It is
7th.
7th of August, Lordship.
So we'll keep it on 7th of August.
What
Lordship.
happened, petitioners are not able to present their status lordship in Shikha Setu, they are now absent in the duty lordship.
But without instructions, what orders can we pass? We need to know what
Their,
is happening.
their name may be restored in the Shikha Setu lordship, otherwise they.
That is your prayer. So let them obtain the instructions why the names are not there. We are connecting both the matters.
Maybe lordship, but in this regard, lordship, matter may be fixed on Friday or Monday lordship, because from Friday lordship, these things are ongoing on now.
You get instructions on Monday. Tell us what is the status.
Yeah.
Third counsel for parties, state counsel, the respondent counsel appearing with the secondary
Lordship, 1, 2, and 4.
education will obtain instructions. Released again on Monday. The extra copies we furnished.
Lordship, as per
In this case, my lord, I am directed to appear for respondent number 2, my lord. We'll file our call number 2 here.
And respondent number 1, lordship. Answer notice was done, lordship.
Who is the respondent one?
Secretary.
To appear.
My lord.
You appear for second respondent.
Fine.
We'll record your name.
Fine.
Or all the three.
3, my lord, as per my secretary already retired.
Retired. Okay.
Retired.
1 and 2. Mr.
Hello,
K.
one.
Bora appears for respondent 1. He submits that he would like to complete instruction. I price the court. The status of the compliance of direction. Raise for 4 weeks time. Release this matter again after.
She will be retired after 3 days. Respondent number
1 and 2 is
three. My lord, I can.
respondents were supposed to comply.
Bless. Service is complete, madam.
What complete?
Service is complete.
Service. Minimum for respondent 8.
Well, wait,
As per laws in the court. Service on respondent 8 has been completed. I will none represents the respondent 8. Mr. D. Sinha is for the petitioner, Mr. PP Tho appears for
Respondent 2 and standing counsel lordship, secondary.
respondent number 23. Pending. Matter be listed for admission. By which time the respondents may file their affidavit if so it takes released after 3 weeks. Done.
Please, your lordship. Then I filed in a disposed of petition, lordship. Lordship was pleased to stay the transfer order of the petitioners for a period of 2 months, lordship. The effective portion is at page number 23, lordship. Second last paragraph, lordship.
Yes.
Allowing the petitioner number 2 to undergo surgery, lordship, if medically advised. Thereafter, lordship, page number 24 onwards is the medical documents. They have been undergoing treatment, lordship. However, the composite hospital has thereafter referred us to the Gauhati Medical College, lordship. The relevant document is at page number 29, referring us to the GMC. And finally, while undergoing treatment at GMC, at page number 35, lordship, if kindly observes that the lower end of the page, lordship, it was stated that the operation is postponed due to low hemoglobin, uncontrolled blood sugar, and generalized weakness. Patient requires medical optimization before surgery to reduce perioperative risk. So the patient rested in the 45 days because weakness of patient health. So Lordship, she has not been able to, this is dated 21st of July 2026. Because of her health condition, she has not been able to undergo the necessary surgery, Lordship. And 45 days rest has been advised, Lordship. So I am praying that as she can only undergo the surgery after 45 days, and the period that the stay order.
Where is the guarantee that you'll be available for surgery after 45 days? That will
These
go on.
documents reflect that I have been undergoing the treatment, Lordship. So
No, you may
this
have
is-
been, but these 2 months was granted by which you may undergo any surgical procedure if
Yes.
advised.
See, Lordship's order is dated 1/6/2026, and my medical documents are from 6/6/2026. All the necessary the documents
What do you
reflect.
say, Mr.
Uh,
Chaudhary?
Ship, that is all right, but I do not see any document from the composite hospital. No, I don't know, but this appears to be from the,
Page
this
24 on
this appears to be from the medical company. In any case, last week, may place it on Friday. I'll just get the.
Friday, day after.
Day after.
The request of the learned DSGI matters like this on Friday, enabling him to obtain the request. Counsel for petitioner is will furnish an extra set of the application to the office of the DSGI within the course of the day.
Much of it.
Yes, Lordship, notice was issued long back on May 2025, but they have not filed reply. However, in the meantime, Lordship, in the post it was wrongly showing SC secondary education. But Lordship, after the last matter was listed on the last occasion, we freshly served copies on SC elementary education also. And it is reflected now in the post list as SC elementary.
Yes, elementary, secondary.
Elementary.
Please, one more time to obtain instruction, Lordship.
The DJ Sharma is the elementary education department prays for the time to complete her instructions and file necessary affidavit. She prays for
3 weeks then, Lordship.
3 weeks time. List up again after 3 weeks.
Actually, this is second round of litigation. It cannot be fixed because it has been more than 1 year now. They have not filed reply. More than 1 year.
28th of August.
Deeply offended.
I think maybe
Attachment order revoked.
Not so. Impugn order is it page, your Lordship, 65, by which the petitioner was transferred, your Lordship. That order has been revoked, your Lordship. And the petitioner is.
This is issued by the BTC. No.
This is
Dhubri.
by the IS, your Lordship, Dhubri district.
Which order was revoked?
Lordship, the order is at, the impugn order is at page 65 of the writ petition, your Lordship. 7/10/2025 order, your Lordship.
None appears for the petitioner on call. It is.
I am responding for seats. I have filed on IA for stay vacating. It's
Is it listed I?
Petition is listed. I have not. I 6/4/26. I the call is there, but
not listed as step-getting column.
You're praying for vacation of which order?
Same order, my lord, in my IM, my lord, annexure,
What was the interim granted?
page 17, annexure, my lord.
That is the attachment order.
No,
Attachment as well as the transfer.
Now the transfer order has been revoked and the petitioner is serving as the in charge. Just the matter is
Let us have it on Friday. None represents the petitioner. Matter of respondents are represented. There's also the applicant, IE. There's also the council hearing the applicant. Released on Friday.
listed on my lord, step-getting column. my lord.
Friday. It'll be listed in whatever column the registry desires it appropriate on Friday.
Please, Your Lordship. Last occasion, Your Lordship ordered it at 27/2026, my lord. The Honorable, my lord, the similar order already, my lord.
Yes.
Praying for
anything?
similar order.
Respondents.
Uh,
Where is the order?
Order, my lord. I have on the order. Date WPC number 3185 of 2024.
3185 of 24. For the respondent here?
Responded by the elementary, my lord.
Elementary.
Elementary, man. Problem is, my lord, they are appointed actually.
Who is for elementary education?
Man. They are appointed, my lord, wrongly as a tutor, but they are have to be appointed as a state teacher. And thereafter, my lord, in director, my lord, elementary verify the claim, my lord, and annexure 9, page 130, my lord. Your lordship.
It's for elementary education. After some time, get a copy of that order. The order. After some time, let the standing council file.
The petitioner was serving as an assistant teacher of an LP school, Your Lordship. And at the time of issuance of the retirement notice, Your Lordship, she has been asked to return back access to Your Lordship. Now, since order is at page number 27, and since then she had also not given her pension and other pension and benefits, Your Lordship.
It's for respondent here.
All here, for elementary.
What are your instructions?
Everything is certain.
But the judgment of the apex court, Your Lordship, is also not permissible.
The amount has been recovered.
Not yet. Like to place the judgment, Your Lordship.
Which judgment?
State of Punjab versus Rafiq Masih. At the time of
Heard counsel for the parties, the respondent counsel submits that you would like to obtain. He prays for renews his prayer for further time. Complete instructions. Petitioner has been sent on retirement by the impugned order dated 27/1/2025, and a further direction was issued to refund the amount which has been, which the petitioner had received as salary during the period of overstay. So, the amount has not been quantified and no direction has been issued for recovery of the
Right.
quantified.
Page number 29.
What about pension?
Nothing has been given. After that, nothing.
What is the amount to be recovered?
They are saying 16 lakhs.
The amount for recovery has been quantified, and it should be 166,157. The petition. So that apart, the pension benefits have not been released by the department. Petitioner was serving as
Assistant teacher.
an assistant teacher. The respondents, there are the respondents, will give their instructions and file necessary affidavit. In other words, the recovery should not be paid. However, the respondents will take steps to finalize the provisional pension. The writ petitioner in the meantime. Released after 4 weeks.
Obliged.
This arbitration petition, I have filed an objection on 24th of 7, madam. That is not on record. And yesterday evening, I have been served a copy of reply to that objection also, madam. Perhaps today morning they have filed. And now petitioners, the petitioner in person, he called me, madam, after some a good time ago, madam.
It is submitted.
Maybe next week, madam.
Mr. K.K. Parasar, CGC, that objections have been filed by the respondents, which however are not connected to the case report. So, further submits that the petitioner has also filed a reply affidavit today morning, perhaps today morning, which is also not connected. Considering the registry will trace out the affidavit objection as well as also the reply filed by the petitioner and connect it to the case record. It's the matter after 1 week.
Obliged.
Dr. Kindly payroll the order dated 12/3/2026.
12.
2026. Lordship, here I need 2 weeks of time to file affidavit. Lordship, I received the instruction.
What is it that you want to show from the order?
Lordship.
The respondent counsel prays for and is granted 2 weeks time.
2 weeks, Lordship. Lordship, date may be
File the affidavit as it is submitted that the instructions have been received. So and so appears for the petitioner. This matter again 2 weeks. The date to be fixed by the registry. Yes.
May it please your lordship. Lordship, in this matter, my lord, I am required to bring on instructions, my lord, but the extra copy may be provided to me.
I'll
Extra copies be furnished to the council for PTC, enabling them to obtain the required instructions. Release this matter again after 4 weeks.
I'm obviously.
Yes, Mr.
Wait, wait.
Mondo.
My lords, actually, my lords, there is no standing counsel for the Bar Council of India. There is a retainer, my lords. Normally, I retain the briefs filed against the Bar Council of India, but I have to take the wakalatnama from the Bar Council. My clerk had accepted the, my lords,
Yeah, so
the
we thought
copy yesterday, my lords, but it was a misunderstanding. It was
he thought it was a pending writ petition. If there's any urgency, Lordship may issue a short notice. I'll take instructions and I'll get my power and address my lords.
Standing counsel.
Heard Ms. Darika, senior counsel, assisted by Mr. D. Hearing the petitions. Do we record your name or we don't?
My lord may issue notice and not required.
The petitioner is the district town of Dibrugarh. Starting LLB program since the year 1965. They have been given the necessary permissions, affiliations, etc. by permission under the Bar Council of India. So the learned counsel for the petitioner submits that every year.
Not year, it depends on the term. Till where my approval is there.
For renewal of the affiliation, what do you call it?
Approval.
Approval for running the LLB programs. The college has been diligently complying with the rules and regulations with deposit of the amount required under the Bar Council of India Act relating to rules. So for the year 2026-27,
correct.
The college had already deposited an amount of rupees 3 lakhs.
3,50,000.
3,50,000 bank transfer.
And filed the necessary papers.
And also filed the necessary and uploaded the necessary documents in the portal of the Bar Council of India. However, the Bar Council of India did not indicate the receipt of the amount, rather it's 4 lakhs is shown to be payable by the college authority for late fee. So this led to the college presenting before the authority, giving a detail of the steps undertaken and the amount which has already been paid. So, response was forthcoming. So, the council for the petitioner has referred to an application dated 3/2026, bracket annexure 9. Submit that this notification is issued by the Bar Council of India for extension of the last date for submission of applications by existing centers of legal education for seeking extension / renewal of approval of affiliation for the academic year 2026-2027. So, learned senior counsel submits that. Is it this or some other notification you can refer to?
Lordship, which
where the cancellation was there?
No, cancellation letter dated 1/13/7/2026.
I think you are referring to this 13/7, yes.
13/7.
Notification. That's billable. Communication dated 13/7/2026, issued by the Bar Council of India, Bar Council of India, to all vice chancellors, registrars, deans, principals, and directors of all universities and existing centers of legal education, imparting legal education. Stop. This communication was in response, communication was issued calling upon these authorities, giving them a final opportunity to submit and complete applications before 31/7/2026. learned senior counsel submits that as per the said communication, it is specified that any application submitted after 31/7/2026 shall not be entertained, except for such specific decisions taken by the competent authority of Bar Council. So it is further stated therein that a center of legal education which fails to submit the requisite application within the prescribed period will not be allowed to claim continuation or renewal of approval or to undertake admissions to relevant academic session in the absence of a valid approval, provisional approval issued by the board. The learned senior counsel speculated the apprehension of the writ petitioner that in view of this communication dated 13/7/2026, there is a serious apprehension expressed by the petitioner that their approval may not be continued for the current year, and they may not be permitted to undertake students for imparting education in LLB degrees. So it is.
If I just add one thing, I just forgot it. Because if I go to my portal to upload, I have to pay 4 lakhs rupees first.
It is submitted that although all the documents necessary, including the deposit of the amount as required, was done by the authorities. However, when these documents are sought to be uploaded in the BCI portal, it reflects that an amount of rupees 4 lakhs, account of
Late fee.
late payment, is required to be first deposited before uploading such documents. The senior counsel submits that when the petitioner had already taken steps to deposit the amount required and submit all relevant documents well prior to the cutoff date, it is no question of depositing a further amount of 4 lakhs, account of late fee, and for non-deposit of which the relevant papers cannot be uploaded in the Bar Council. So it is further submitted that these steps taken by the petitioner were duly intimated to the Bar Council by their communication dated. When did you send it to Bar Council?
Second time again, Lordship. I sent it second time again after I got this letter.
Okay.
NHA 8, Lordship, page 48.
2007/2026, which had remained.
On 27/2006.
2007, yes, 2026. And however, the grievances have not been redressed. Being agreed, the present writ petition is filed. Considering the submissions issued, submissions made before the court, and also considering that the college of the institution is required to take necessary steps for inviting applications for undergoing the LLB degree course, the current year 2026/2027. Formally notice issued returning steps on the respondents by speed post within 3 working days. Having perused the pleadings before the court and also for consideration the submissions made, seen that by the indication dated
Letter.
the notification 3/2/2026 issued by the Bar Council with respect to the extension of the last date of submission. Sorry, not this, the other one.
Yes.
My lord is contemplating on passing an interim order, my lord.
Yes.
That case, my lord, I'll take notice. Lordship may take it up tomorrow, my lord. Lordship, hear me, and rather than passing an ex parte ad interim order, my
We
lord.
asked you, you said the notice should go.
Since I have already received the copy now, yesterday copy was also. Lordship
No,
would issue
we-
notice. I'll take notice today.
We have no difficulty. The question is whether you are authorized to receive notice.
I'm
If you are-
authorized. I'm
if you
authorized
are,
to receive notice, but I'm not the standing counsel. I'm authorized to receive.
Then why did you not mention it before the court? We are asking you.
But how
No,
can
no,
he
my-
not receive a
notices
copy
were-
is not the standing counsel?
Notices were not issued, man. Notices were
How
not
can you-
issued now since the.
You are making
My lord.
double submission. What is this?
He cannot.
Either
accept-
you accept notice, whether you are
Yes,
standing
yes,
counsel or
yes.
retainer counsel, we are not concerned with the terminology.
Right, man.
We are asking you whether you are competent to accept notice.
I'm
The
competent.
answer has to be yes or no. We are
I'm-
still waiting for an answer.
No, I'm not supposed to take an extra copy because I'm not the standing counsel. If notices are
We are
issued,
issuing notice unnecessarily. Don't waste time. You're not authorized, say so. There's nothing to be scared about. If you're not authorized, you're not authorized.
in that case, Lordship will not record my name.
Issue notice on so taking into consideration the application issued by the bar council. Application dated 13/7/2026, where there's a specific provision for non-approval. Or renewal. Of the institution to undertake admission in the relevant academic year. The next returnable date. Steps taken by the bar council to cancel or withdraw the approval, the renewal, the institution, taking into consideration that all necessary documents, including the fee required as deposited, without the legal matter be listed. 21st.
Any day.
21st of August.
Deeply aware.
Also, next one is also same. I do never the amount.
Which item is it?
55. It's the same.
50?
55. Only the
55.
amount is different. Amount is 8 lakhs.
54, 55.
And the communication date is 18th. We'll give the correct.
The same communication is there, same date.
Same date, same date. We sent our documents on the 18th.
That date you mentioned it.
And
you sent your documents on which date?
18th.
18/7.
18th.
Send him item 55 by the authority, by the complaint authority. 18/7.
18th. Amount is 8 lakhs.
Amount is
8 lakhs.
8 lakhs. Why is that? Why is it
Because I have 3-year LLB courses as well as 5-year BA.
integrated? Okay. Amount of 8 lakhs. I would 3 lakh. 3 lakh 50.
4 lakhs. Right.
And then 55.
Pertaining to the last order, we'll be filing our affidavit, additional affidavit by tomorrow or Friday next week. Some additional instruction I have.
Lordship, by the last order, allowable court asked to show the duplicate original of the certificate.
Mr. B. Gogoi additionally state something that you'd like to file additional affidavit
Additional affidavit
within 1 week.
within 1 week.
1 week. The matter therefore be listed after weeks. What is this?
Lordship, these are certificate and admit card of the HSLC that was asked to this before the honorable
You
court.
show it on the next date.
Lordship.
Show it on the next date, take it back.
in item 37, I've just gone through the affidavit filed by the principal lordship, wherein it has, at para 6, it has been stated that there is some internal inquiry held, and that outcome has not been communicated to them, for which they are not processing the pension papers of the petitioner. So lordship, I'll get the instruction whether what happened to the inquiry, lordship, which was conducted, lordship. So let me have a week's time, lordship. I'll get
Yes.
the
Lordship, last sums may be given because I'm deprived of my pension. Lordship.
Why don't you settle for interim pension, provisional pension? Have you received provisional? S.M. Bora for the petitioner, Mr. D. Manus, appearing for the
higher
higher education department. Submits that you'd like to obtain instruction with regard to the status of the inquiry, which was initiated against the petition, and because of which perhaps the pension has not been released. So let this information be placed before the court within a period of weeks, 3 weeks. So meanwhile, in the event the proposal for regular pension has not been submitted by the department, they will take all steps for release of the provisional pension. Mr. Talukdar for respondent 4, Mr. Smith for respondent number 3 in WPC number 7341, and
I am for 430.
and in WPC 6402 respondent 5. Mr. Talukdar is
6402.
640 respondent
4 minor.
4. Anyone in 7341? After 3 weeks.
Alia.
Matter pertains to alia pension benefits. In this regard, I have received one instruction whereby the inspector of school Kolkata was asked to furnish some documents regarding. Actually, there is a problem that delayed submission of pension papers. So, Rule 205 and 206. Therefore, this. These documents are asked to be filed by the IS. And this letter was on 18/5/2026.
Yes, respondent.
I am for respondent 7, principal.
Principal.
Yes. I have.
Why did you not furnish send the proposal?
I have reconstructed the service book, lordship, and it was forwarded on 29/2022.
Who's for secondary education? Secondary education, please tell us why there was a delay in forwarding the pension proposals.
Women is the one, your lordship. Please,
Now the pension proposal is returned to the IS of Kolkata.
Returned.
Returned.
You have to give a reason under Rule 205 and 6 as to why there was a delay.
The instruction is received, your lordship.
Received. What does it say?
As per the letter, your lordship, it was later dated on 28/7/2026, your lordship, with reference to the subject cited above and this department letter under reference. I am directed request your kind attention to the matter wherein your office was requested to furnish certain documents, information in respect of late Sirajul Haq, ex-classical teacher of Langla Higher Secondary School, Borpeta district. And however, the requisite document informations are yet to be received as the matter relates to the relaxation under Rule 205 and 206 of the Assam Service Pension Rule, 1969, and it requires the approval of His Excellence, the Honorable Governor of Assam. You are requested to accord the matter to top priority and furnish the requisite documents information at the earliest to enable this department to further necessary instruction. Since the matter is listed for hearing, Honorable Court on dated 29/7/2026. So, Your Lordship, kindly grant us some time. Your Lordship, letter has already been forwarded from Joint Secretary to the Government of Assam.
When?
28/7/2026.
So this letter is forwarded seeking what?
Your Lordship, for the relaxation, Your Lordship, under Rule 205 and 206 of the...
Forwarded by whom and to which office?
Your Lordship, from Joint Secretary to the Government of Assam to DSC, Secondary Education, Director of Secondary Education.
Who is supposed to relax it? The governor. You have to send it to the governor.
Your Lordship, that will pertaining to that, Your Lordship, they will definitely forward it, Your Lordship, because here it is already been mentioned, Your Lordship, to the Governor of Assam, Your Lordship.
You get your instructions, get clear instructions from your clients and apprise the court why the proposal has not been sent. This is somebody's pension and he is languishing for 35 years. Or we'll direct stoppage of pension for all these persons when they retire. Get these instructions within 1 week. Council for the Secondary Education will obtain clear instructions with regard to the steps undertaken by the department for seeking a relaxation from the appropriate authority as mandated under Rule 205 and 206 of the Assam Services Pension Rules. So, the council will apprise the court the steps undertaken by the competent authority in this regard. Let this matter be listed in on 7th. Let us give you some more time. 12th August. Please convey that clear instructions are required. Who has taken what steps? Mr. S. Alam. Appears for respondent number 7.
Actually, your readings are complete, my lord. So, matter may be fixed for admission during.
What is the matter?
Matter relating to the non-payment of areas as well as current salary. This is a third time litigation by the petitioner. On the strength of alia order, the petitioner received lump sum 36,000 per person in the year of 2015. Thereafter, in 2019, petitioner approached before this court, and after that, there are current salary as well as their salary years not paid by them. And the respondent stated in their affidavit that petitioner were terminated from their service in the 2004. But fact is that petitioner is still working minor. And let them take instruction whether the present petitioner were working or not, and whether they did not annex any termination order in their affidavit also. Working as mother teacher, only under monthly pension of ₹500 per month. Very petty amount.
Why have you not given the area?
Lordship, as per policy decision, my lord, some mother teachers, LDA and gardeners, some were appointed against
non-sanctioned and non-existent posts, my lord. And thereafter, my lord, that posts were created under new education policy by the erstwhile BAC, my lord, in the year 1997, my lord. Thereafter, policy decision was taken, my lord, and they were all were terminated on 12/10/2024, my lord. Thereafter, petitioners have already received their arrear salaries, my lord, till the termination.
Where are your appointment orders?
Appointment orders, they started from is 20. 19 is a type copy. They're still working, my.
It's still working.
Still working, my.
Lordship,
Still working. No termination order was issued to the present petitioner. I don't know whatever the others.
Your affidavit, does the affidavit reflect anything on that?
No, my lord.
Then
Because, my lord, as per the affidavit, my lord, they were terminated, my lord, way back. And thereafter, their arrears were released, my lord, for the period they were working, my lord. That is rupees
how many
36,000.
petitioners are here?
12
12
petitioners.
Working in the same school?
Same school, my lord, from the date of joining.
And these, my lord, these writ petitions, my lord, the lordship, they were
Earlier they-
dismissed, my lord. And some were found to be not paid. Some petitioners were there, my lord, who were not paid their salaries. And upon direction of this honorable court, they were paid, my lord. And these petitioners has already been paid, my lord. So they have come again for the second time for the arrear salaries.
They received 36,000 per,
Because there is
per
no
person,
person.
my lord, as a lump sum. And after that, they were not paying it.
You did not make the headmaster or principal of the school a party. Because if you are working in that school, then there has to be some documents to support your contention.
I have annexed the working certificate, my lord. They are still working.
Working certificate,
CM signature.
Lordship,
so you are working under whom? Where is that certificate? Show us one certificate.
Is 90. Type copy.
19.
90. One of them.
90.
91 is the
These are
original
the
one.
headmasters, my lord. Certificate issued by the headmaster.
The headmaster.
Yes.
is
When
the-
we file an additional affidavit, the headmaster, that the headmaster is certified that the petitioner is still working on. And if it's good, I will include it as a party.
You have to implement the headmaster as a party.
Yes, ma'am. I will include the
Counsel
all
for the
the headmasters.
petitioner submits as a claim to the writ petitioner is their arrears claim salary for services rendered as what? Mother teacher.
all are
They are-
mother teacher.
What is their
They are LD and Gardner.
No, mother teacher.
mother teachers?
Mother teachers.
In which school?
In different school of, under Jala block.
In different schools under
Jala block.
Jala,
Jala block under BTA.
under so and so.
It is what?
PTA. So it is a claim that the petitioner that their in spite of services being rendered, their ADS salary has been released. Then the respondent BTAD had filed their counter affidavit disputing the claims of the petitioners, saying that they were already terminated and whatever salary was required to be paid is already being paid. However, the claim of the petitioner that they're presently working and area salary is payable to them has been disputed. So, in rejoinder, the counsel for the petitioner submits, files the rejoinder affidavit to submit that they are still engaged in rendering their services, and therefore, the respondent for duty bound into their service salaries. So, reference has been made, certain certificates issued by the headmasters of the concerned school. So, however, it said headmasters of the school were certified that the petitioners were serving and not aided as a party. So, counsel for the petitioner seeks liberty of the court, take necessary steps for filing application for airing the respondent, the teacher, the headmasters, party respondents. She prays for
2 weeks time.
2 weeks time. We list this matter again after 2 weeks. Anyone else appearing? Open for education.
Lordship, UGC. And
So what is the punishment imposed? Suspension.
suspension from Lordship,
What is the punishment imposed on you?
July to November.
On me, your lordship, 5 penalties have been imposed. There is annexure P1, page 31. There is suspension of classes. I have been expelled from the hostel. An unconditional apology that I have already submitted. And I'm
This
not
is as per the UGC rules.
Yes, lordship.
UGC has laid down the criteria, what kind of punishments to be imposed.
But lordship, this penalty number 1 is completely against me because only this punishment was given to me only. And so far as criminal prosecution is there, FIR has already been registered against me.
Have you filed an appeal? Have you filed an appeal against the order of punishment? There is a provision for filing an appeal.
No, lordship, no appeal has been filed.
You should file an appeal because the rule says you can file an appeal.
Because the semester is going to start from August.
Mr. Counsel, first thing you admit that you had indulged in ragging. You admit?
I admit that, your
You
lordship.
admit.
Not ragging, your lordship, but there was no intention of ragging.
Whatever it may be, you admit that there was some issues on the basis of which complaints were raised. The matter was looked after by the committee which is framed in terms of the UGC norms. They have deliberated on these issues. They have issued a punishment, which appears to be a serial number 1. That is suspension from attending classes. You are entitled to file an appeal as per clause 9C. You can file an appeal to the university or the VC of the university. What will be the effect of the suspension of classes?
No, Lordship, as my instruction that he thinks that the counseling which is done, given to the scope of counseling given to the students in our 3rd year, that will be missing. But the counseling start from 21st of 26, Lordship, this year. Only 21st of 26, it will continue till May 27. And he's only 7th semester only. 7th semester complete. He might miss some classes because it's punishment. But there are instances the students when they make an application to the authorities, they provide extra classes to them at the institute's cost. Provided he makes an application. If he makes an application that I was not debarred such and such, then we have been doing extra classes to give. So that facility is given. But we cannot escape from giving any punishment to him because this is that if this is
punishment is mandated by the rules.
Your lordship, but why only to me? There are other students also.
All right, we'll direct punishment to be imposed on the others also.
Yes, your lordship, my
punishment.
One submission is that, your lordship, for the sake of argument, your lordship, I am a 21-year-old student. And your lordship, and
we have understood everything, but you tell us that these rules are very categorical.
Your lordship,
the rules lay down that there is a committee which is set up in the institution and they will impose punishment as per the
I admit that, your
notified
lordship,
punishment.
but my submission is that am I not a habitual offender, lordship? I am only a student. I am already facing one FIR.
Therefore, you file an appeal before the authorities.
My request is that, your lordship, at least I may be permitted to get admission for this semester, and remaining all the penalties I will acceptable. I will also have to face the FIR. I'll also have to face the trial in the trial court. So my request is that what am I going to do for the upcoming 6 months, lordship? Looking all my batchmates going to the college, I'm sitting in my
should have thought about it before you had indulged in these irregular,
but lordship, why only this semester suspension to be? That's what I'm asking. Let the fine may be imposed upon me, your lordship, but I may be given an opportunity to appear in the exam. Just, your lordship, one opportunity may be given to correct my mistakes and to be a good student and a good citizen and a good human being. One last opportunity. In many occasions, Indian judiciary has given opportunity to the offenders to change their lives. All I'm requesting, I'm only a student, Your Lordship, having a bright future. One opportunity may be given, it may change whole my life. I've already learned a lot of lessons. I'm already facing FIR, facing a lot of mental distress. And my family,
Yes.
At the same
one
time, that's-
opportunity may be given.
Is it possible for you to accept an application for reconsideration of the
if he can file an appeal, that will be considered definitely. He has got right to file an appeal against his punishment. But condition of this young boy who just passed out the school, that also has to be looked in. And if after having committed this thing to that young boy, he just passed out from the schooling. If it is well settled, if you
No, the question is, this victim is a resident.
no,
He's a boarder.
He's a freshly admitted student, fresher.
Is he a boarder in the hostel?
Yes, he's a boarder in the hostel.
Right. And this petitioner is also a boarder.
He's also boarder of senior
Now you have thrown him out of the hostel. Petitioner.
Yes, Lordship.
So there is no occasion for the petitioner to come and harass this boy in classes because he is the first year student and he is a seventh semester.
Having committed the ragging that has been established, if you show any leniency, firstly you violated EDC's.
That is for the law to take its course.
Lord.
You have taken your step.
Lord.
You are an institute of excellence.
Lord.
For a person to get admitted in an institute like IIT, they virtually have to give up everything in their lives, go for the extreme hardship, preparing for the examination.
Correct.
People make mistakes. Now, you have imposed the punishment. We are not commenting on this. There is a provision for an appeal. Let him file an appeal.
Let him file an appeal. Lord.
We will expect the IIT to reconsider punishment imposed on him in respect of suspension of classes, not in respect of his residency as in the hostel. He may, please ask your assistant counsels not to interfere when the court is interacting. You have imposed the punishment of suspension of classes.
Lord.
This is the major penalty according to the petitioner because he's going to lose out in his academic year.
Not year, Lordship, but semester.
Whatever
which can be
semester,
double.
if he semester is for 6 months, if he misses out this semester, then his entire academic year goes back by 6 months.
Not
maybe more.
Because January he can take extra classes. Something he has to pay. Lordship. We provide extra. We have many instances. We have provided extra classes to the boys to make up. Some rigor he must go through.
What rigors? What rigors do you want?
Some sort of.
Firstly, what is the superintendent of the hostel doing? Who is the superintendent of the hostel? What action have you taken against the superintendent of the hostel? Is there or is there not a superintendent of hostel?
There is definitely
there
one,
is,
but there is not.
There is yes or no?
There is definitely.
Then what action have you taken against the superintendent? What is the purpose of entrusting the responsibility on a superintendent when things like these go unnoticed, unreported, and you are ventilating your shortcoming on a student alone?
Not certain student only, because other action will
What actions have you taken against the superintendent?
That I'll find and take instructions. But
why you filed an affidavit? These things should have been a part of the record.
But superintendent cannot be state of blame. Not if that's at 2 a.m.
We don't know.
Senior boy.
We don't know. Are you telling me that the superintendent is incompetent to decide to find out what is going on in his hostel? That person should be stripped of the responsibility with immediate effect.
The hostel board is hostel administrative board. They have taken action after that.
Mr. Counsel, please don't try to explain as to how to manage hostels. If you are incapable of running hostels, shut it down. Once you have opened a hostel, you have appointed a superintendent, there is a board. You can't wash your hands to say that, oh, it's left up to the students, we don't know what they did at 2 o'clock.
Taking is such a mandate it is coming in, that has to be somehow or other, it should be stalled. And unless some exemplary punishments are given, here he will not be missing anything except that he will have to undergo some extra classes. Or let him file an appeal, or institute will consider the appeal.
Extra classes for somebody who's at the threshold of passing out of an institution has a very strong effect. You're not a student anymore. I'm not a student anymore. Missing of extra classes for you and I, and for a student, that too in an institute like IIT.
Has to, because
Has to be understood on its own
very
perspective.
seriously. I'm also sympathy to the boy, senior boy.
Mere sympathy,
that
mere
has to be
sympathy is
lordship.
not good. You have to find out. You allow online classes. If you don't want him to come to the college premises, you allow online classes. What stops the IIT from giving online classes?
But
So that he doesn't miss his classes.
let him apply for that. But these are the punishments.
Have you indicated that this provision is there? Let him go and apply for online classes. He can have online classes.
Provisions are there, not lot of things go in discussions. So let him file an appeal, lordship, that all these aspects to be considered.
We'll direct him to file an appeal, but he will not impose the punishment until the appellate authority decides.
Yes, sir.
We are giving you an opportunity to
And
find
it will be the
an
term-
answer to the problem. If you are too rigid, then we will have no options but to pass an order.
The lot of situations, lordship may judge what is best. But this ragging is a dangerous thing. It's very, it's a cancer.
We are not saying it is not. We
Therefore,
are not
lordship,
saying it is not.
and we have found
What
it
what is the purpose of imposition of punishment if not for rectification? You have not debarred him from classes. You have not rusticated him. You have stopped him from attending classes for 6 months.
6 months. Yes, lordship. Something.
If you feel so strongly about it, you should have rusticated the student. That is not fit to be a student of IIT.
We are not going to the extreme stage.
Then?
But some realization must happen to him. He must have. It's a ragging. It has to be somehow or other stopped. Showing sympathy when this is law is also
No,
so
sympathy need not be misplaced. We agree, but you are imposing the punishment. Where are the minutes? Where are the minutes of this?
Page 96 is done.
Lordship, but ARC is 96, Lordship. But it will be last.
96.
Lordship, page 96.
Yes.
That is that anti-ragging committee's meeting, first meeting. Reported Lordship may kindly peruse page 93. 1 second. His admission, Lordship, that is very clear. Not 93. I'm sorry, Lordship. This is what is it? Admission. Page 90. First meeting get here. Page 96. Lordship, that
The first meeting.
first meeting. That Lordship may kindly read to next page, page 97. As per details provided in the complaint. That's on 26/3/26, Lordship. Got it, Lordship. Student A was present, student N with the victim student at the Lohit hostel canteen when he received the telephone call from a senior student, Mr. Pankaj, who inquired about his whereabouts. After student A returned to his own hostel, Manas hostel, he received a subsequent call from his friend, Mr. Jatin Mehra, email Sasensas, BTech student of the Sasensas students. Since the artificial intelligence who asked him to speak to someone, the call was then taken over. Sasensas, next prayer lordship. Upon reaching room number, Pankaj, who instructed the student A to report immediately room number D310, Manas hostel, which is occupied by Yoga Sasensas and Jasachars. Upon reaching the room number D310 at approximately 2 a.m., student A was asked to wait briefly outside. Shortly thereafter, the Jatin Mehra exited the room and student A was called inside. According to student A's statement, several senior students present in the room appeared to be under the influence of alcohol and were smoking heavily. Student A expressed discomfort due to the smoking. After some time, he was instructed to stand near the balcony side of the room. As per the audio evidence submitted by student A, while he was standing, because he was having the mobile in his pocket, that's victim boy. So conversations were recorded. While he was standing on the balcony, Mr. Utkarsh, the Reed Peterson Gupta, who serves as the cultural secretary of Manas hostel, began shouting loudly at student A for approximately 2 and 3 minutes using abusive languages. Student A was reportedly forced to keep his head down and remained standing throughout this period. Thereafter, Pankaj repeatedly compelled student A to disclose his voting choice in the recently concluded student Gymkhana elections, despite the confidential and private nature of the secret ballot. Upon students A's refusal to divulge this information, the intensity of verbal intimidation increased. Student A further alleged that Pankaj made inappropriate remarks involving his father. According to student A, the interaction appeared to be coordinated and amounted to an illegal interrogation aimed at extracting details of his confidential vote, conducted under severe duress and intimidation, thereby violating fundamental principles of electoral integrity. The election had taken place prior to that problem. Due to the loud commotion during the early morning hours, the hostel caregiver and a security guard arrived at the location and inquired about the situation. During this process, the student A was asked to move from the balcony to the corridor side, and the senior students were discussing bringing other seniors to further harass the student A. Overwhelmed by the incident, the student A broke down and began crying. Upon being questioned by the caregiver regarding the disturbance, the student A narrated the event that had transpired inside the room. Recognizing the seriousness of the situation, the caregiver began recording student A's testimony on video and subsequently escorted him to the library on the first floor. During this time, another senior student, Mr. Sasansa's gang, arrived at the spot and provided initial emotional support and counseling. The caregiver then asked student A to submit a written statement. However, as his request was made in presence of some senior students, student A submitted a statement indicating no complaint and signed it falsely under duress. In consideration of student A's safety and caregiver immediately allotted him a guest room, room number such near the security control room, and asked him to rest. At this point, student A provided his actual statement regarding the incident in support of his video testimony. On 29/3/2026 and approximately at 10 a.m., the student A met the warden of Manas Hostel and narrated the entire incident, including the continued perceived threat and pressure from the senior students. He further reported that senior students attempted to coerce him into providing a fabricated account, claiming that the incident pertained to merely a discussion about Sahayog module. Subsequently, on 2/4/26, the warden of Manas Hostel convened a hostel discipline committee meeting and inquiry into the matter. The meeting was attended by the chairman, hostel affairs board, the warden, and the associate wardens of Manas Hostel. In view of the students' A's request that the statement not be disclosed to any student representatives, his recorded statement was forwarded by authorities for further consideration. Statements were so recorded from all other involved students, namely Yogesh, Mr. Ukras Gupta, the petitioner, Mr. Pankaj, Mr. Bhanjari, Sasanchas. These are the students' names. In now let's make kind of deliberations. I skip up three paragraphs. Deliberations. On the same page. At the beginning of the meeting, the chairperson of anti-ragging committee presented the details of the complaint filed by the student to all the committee
Now,
members.
let us come to your recommendations, page 110.
Page 110. I reading.
No, you just want to know. These are the final recommendations.
Lordship, well, it is subsequently, thereafter Shoko notice was given to him, he finally replies, he was heard, then the final order was passed of this.
No.
That is Lordship in page.
These recommendations are passed by what? The anti-dogging committee.
Lordship.
Then what happens?
Thereafter,
What is the procedure?
Lordship.
What is the procedure? Where is it?
Thereafter Shoko.
Where is it reflected in the rules?
And
What
that
procedure do we follow?
Thereafter Shoko's notice was issued to the student. At page 128.
128.
Lordship.
By which committee?
This anti-lagging committee, Lordship. Oh, that's a, that, I'm sorry, page 128. Yeah.
120?
Page 128.
Yes.
Assures students, head of the section, students affairs.
This is what is the show cause for?
Show cause notice under the provisions of the UGC regulations on curbing the menace of ragging in higher education institutes, 2009. Ordinance of, this is IIT's ordinance of code and conduct of students, Indian Institute of Technology, Gauhati, with regard to the ragging complaint received from a first year student. This is Shoko's notice to him. And also kindly see his replies. Page 133 is the reply given by the petitioner. So the head of the section, Lordship, page 133. I see such and such as next page. At the outset, I used to sincerely and unconditionally express my regret for the incident that occurred during the night of 25th and 26th of March. Upon deep reflection, I fully understand that my conduct during the incident was extremely inappropriate, emotionally driven, immature, and unbecoming a student holding a position of responsibility in the hostel. I acknowledge that my words and behavior caused discomfort and psychological distress to a junior student, and for that I am genuinely remorseful. I respectfully submit that I never intended to raise my voice and shout at a complainant. The incident arose out of accumulated interpersonal misunderstandings, emotional reactions related to prior hostile interaction and hostile election activities, and my own failure to exercise restraint and maturity in handling the situation. I humbly request the committee to kindly consider the following facts and circumstances while evaluating my conduct. Acceptance of misconduct and expressing remorse. I sincerely admit and regret that I called the complainant to the room at late night hours through another student. I shouted at him and in anger and his abusive language during the interaction. My behavior created an uncomfortable atmosphere for a junior student. I failed to maintain the standards of conduct expected from the student of IIT Gauhati. During the initial hostel disciplinary committee proceedings, I did not truthfully disclose the complete facts due to panic, fear, and emotional distress regarding the consequences of my future life because of the incident. I deeply regret all the above actions. I fully realize that regardless of my emotional state or intentions, such behavior was inappropriate. I also sincerely apologize to the affected victim, the institute authorities, hostel administration, anti-ragging committee, and the entire IIT Gauhati community. 2. Clarification regarding nature of incident. While I sincerely accept responsibility for my inappropriate verbal conduct, I respectfully submit that certain aspects of the incident may kindly be viewed in the proper context. Lordship, may kindly the
Yes.
one page, 142. That is the final recommendation. The first few we have, I start from the it is petitioners, all students are separately served, not that same so-called notice is depending on the their involvements, they were lordship charged. Now I read from lordship that the committee has since received written responses from all the concerned students. Page 143. In the present meeting dated 25/26, the chairperson narrated the sequence of events following the first meeting held on 13/4/2026, including the formal complaint filed at the police station on 19/4/2026. Further, the chairperson placed before the committee the replies received from the students in response to the so-called notices and read them out in detail upon review. Now, Lordship will consider conclusion part.
When are you required to take your admissions?
This month only, Your Lordship. From August, the classes are going to start. Already started. I've been delayed because of this penalty.
You have a provision for an appeal.
Your
Under the
Lordship,
rules.
my request is that may the matter be kept pending. I will be applied there, and a limited time may be given to decide my appeal. And if the appeal will be accepted, or else I'll come back to the court. Only with regard to penalty one, Lordship.
Why don't you furnish an opportunity to attend classes through VC? Virtual mode?
That provision not there, but if Lordship directs them, I will talk to them, Lordship.
Get your instruction, find out. As it is, he is required to vacate the hostel.
Online classes, Lordship service. But
yes. See, in the recommendations, where are the recommendations?
Lordship is seated.
Recommendation is 110.
Page, Lordship.
110.
149. Lordship.
No, 110.
That was the first meeting, but now.
These are the recommendations.
Now, Lordship, that final recommendation at page 149, Lordship. Student wise.
That's right.
That is in 149. Later portion, Lordship. Mr. Utkarsh Gupta, lead petitioner. That page, Lordship. Mr. Utkarsh Gupta be suspended from attending classes and academic privileges with immediate effect from July to November 26 semester. He may be allowed to register in the subsequent semester from January 27. Utkarsh Gupta's accommodation in the institute hostel be suspended with immediate effect for the period from July to November 26 semester. The hostel room be vacated immediately upon receipt of the letter. The Utkarsh Gupta be directed to submit an unconditional written apology letter to the chairperson, anti-dagging committee, IITG. The written letter in the original must be submitted to the head of section, Student Affairs, IIT Gauhati, such and such, within 15 days of receipt of this letter. His earlier post of Cultural Secretary of Manas Hostel be revoked immediately. He should hand over all responsibilities in any pending to the warden of Manas Hostel also. He should submit an undertaking that he will not use his position of responsibility in any future official correspondence. Utkarsh Gupta be not allowed to represent the institute in any capacity and not be permitted to hold any position of responsibility in the future. This is about the petitioner. The only punishment is that actually number one is the only punishment. Others are automatic or mechanical. Number two, that his classes are suspended. Number two, accommodation in the institute hostel, that is of course a lighter punishment. Utkarsh Gupta be directed to submit an unconditional apology. This is not a punishment, Lordship. Fourth, His earlier post cultural secretary that has already gone, he cannot utilize it. Fifth, Lordship, Utkarsh Gupta be not allowed to represent an institute. It is not a punishment, Lordship. Only punishment. And the second, Lordship, the student Pankaj, he is also giving a similar punishments. All depending on degrees of involvements, the punishments were given to them, and charges were also given.
Lordship, I am only a student and I'm requesting I may be given a permission to attend the classes. I may be given a fine, I may be given all the punishment. I will stay in the PG room. But if being a student, it will leave a very bad impact on my mind, Your Lordship. Sitting in my home for 6 months, looking to the other students going to the college and universities. It will leave a
This
very
is what is mandated by the rules. UGC rules.
Lordship.
The
I
UGC
admit
rules are
that, Your
very
Lordship,
clear. The punishment to be suspension from attending classes.
I may be given an opportunity to make appeal, Your Lordship.
You
At
file an
least-
appeal. That appellate provision is there. You file an appeal.
Until then, Your Lordship, this matter be kept pending, Your Lordship.
You file an appeal.
A fixed time may be given because classes are already started.
You have to file an appeal. When do you intend to file an appeal? When do you want to file an appeal?
This week only, upcoming Monday.
Where is the provision for an appeal?
Well, Lordship, page, Lordship, page 91, Lordship. Our code of conduct. Institutes. At, Lordship, at page 91, appeal procedures, clause 6 at the bottom. A student can appeal to the appellate authority against any punishment imposed upon him, her. He should appeal in 2 weeks' time with proper justification of the appeal. This is available to him.
Page number?
Page 91, Lordship, or our affidavit, Lordship. This is the ordinance of the IIT, students conduct ordinance of the IIT.
Lordship, my request is that on Monday I will come. I will stay in the PG and I will file immediately the appeal for the concerned authority. Till then, Your Lordship, a direction may be given by this honorable court so that I can go there and file the appeal.
Appeal you can file. You don't have to physically come. You can file it through online.
Yes, Lordship, I will do it.
File it.
Till then, Your Lordship, the matter be kept pending, Your Lordship. It's my request.
Yes, right. Copies.
Your Lordship, one more request.
In deference to the earlier order, respondents have filed their affidavit. The affidavit, you will see that matter was examined by the anti-ragging committee, the IITG. 6, pursuant to which interim recommendations were made. Thereafter, this were issued to all the stakeholders and we granted opportunities to be heard. The committee passed final recommendations. So, insofar as the petition is concerned, the recommendations are as under page number. Petitioner, the petitioner agreed primarily by the imposition of punishment as per recommendation of serial number 1. Punishment of serial number 1 recommendation. So, being agreed, he has approached this court, seeking a direction from the court, the respondents to permit him to take admission. Which semester?
Eighth semester.
Eighth semester, so that he may complete his studies, the IITG for the
Your Lordship, it should be fourth year, so the whole semester will be covered.
fourth year.
Fourth year, final
Fourth
year,
Final year. The BTech,
BTech chemistry.
in which branch?
Chemistry.
Chemistry. So, chemistry or chemical engineering?
It's chemistry. Your Lordship.
The respondents on the other end, by filing their affidavit, has contested the matter. The claims in the petition are saying that the process undertaken by the institution, the anti-ragging committee, and the final recommendations are in terms of the UC, namely C regulations on curbing the menace of ragging the higher education institutions 2009. Senior counsel guide subjects that it provides for administrative action in cases of the event of ragging. Institution required to impose punishment on a student found guilty of ragging after following the procedure, and the punishments imposed, the punishments that may be imposed: suspension from attending classes and academic activities. In fact, the first punishment listed across 9 bracket B. Therefore, submits that whatever has been done by the institution strictly as per the 2009 regulations, and more particularly view of the clear admission by the writ petitioner. Therefore, submits that interference is called for at this stage. It is further submitted that the apprehension expressed by the petitioner that south selling is incorrect, as the counseling its batch will also continue in the year 2027, by which time the petitioner can enroll the semester from which he is presently suspended. So, there are having heard counsel for the there is a lot of readings available. As also the regulation of 2009, it is seen that against the punishment prescribed under regulation 9 of the UGC so and so regulation, an appeal against the order of punishment lied the Vice Chancellor of the University. Or Chairman or the Chancellor of the institution in the case. Stop. The counsel for the petitioner submits that he be permitted to prefer an appeal immediately as prescribed under Rule 9C, and the writ petition be kept pending. Further direction be issued to the respondents to dispose of the appeal that may be filed with the petitioner and pass effective orders. The prayer made at this stage by the counsel for the petitioner is objected to by the counsel for the respondent. Submits that the appeal may be preferred, and the appeal and pass appropriate. Considering the issues involved and submissions of the parties, it is granted to the petitioner to file an appeal in terms of Rule 9C, the competent authority within 1 week.
Yes, Lord.
In 1 week. And the same be disposed of by the competent authority within a further period of how much time?
Lordship, 1 month.
1
1 month.
1 week.
2 weeks will be better, Lordship.
2 weeks thereafter. So, how is the appeal to be preferred?
Novel format, Lordship.
Where is the format available?
That our ordinance code is there available. So we have annexed it.
Or we can make a simple letter format.
That also you can do that.
Yes,
Lordship. At page 82, we have annexed the ordinance of code of conduct of students. Simple format, Lordship, that at rule 6 of this ordinance says about the appeal.
We can make in a simple formal format. Your Lordship. It may be accepted in.
The appeal may be preferred by the petitioner as per the format available or in a plain paper and submitted immediately to the concerned authorities. Whereupon the same be disposed of. So, the parties will apprise the court with regard to the status of the appeal that will be preferred by the petitioner. The next date of listing, which is on 21st of August.
Much obliged.
Item 29.
Yes, please, Your Lordship.
Covered.
My lord, the similar my lord order, my lord.
Covered.
My lord
Order,
order, my lord.
the order. Who has supplied this order?
My lord, on 19/12/2025.
Yes, that order.
WPC number, my lord, 3185.
Similar order.
Similar order.
We heard this was. Yes. This was.
Much.
We'll just verify. We'll verify whether they had the qualification or not.
Everything is there, my lord. Order, my lord.
Good.
Much.
And in this case, the respondent has filed an affidavit in opposition. 10 days time may be given for.
Mr. R. Islam, legal aid counsel, prays for and is permitted week's time to file the rejoinder. The affidavit filed by the respondents, realistic accordingly, after 10 days, after 2 weeks.
Much.
Yes.
Milord, the matter relates to Milord. I was working as a lecturer in Diet Milord, Hailakanda. Thereafter, Milord, I had been Milord taken leniently and gone for Milord posting as a MSW, Milord, medical surveillance worker in the health department. Now, Milord, my application, Milord, for the purpose of allowing me to go on lien, Milord, had been accepted and Milord allowed also. Later on, Milord, when I want to come back from my Milord lien to my parent department, Milord, as the Diet, that had been rejected, Milord, and that rejection order, my Lord, may be pleased to find, Milord, is at page number 58.
Yes.
So, my Lord, this is under challenge, my Lord, that I am directed to state, my Lord, at page 58, my Lord, may kindly have a look, my Lord. In inviting a reference to your letter on the subject cited above, I am directed to state that the government of Assam in elementary education department regrets that the proposal for granting of lien in respect of so and so Kaligans cannot be considered due to non-confirmation of her service and her period of service is less than 3 years, which is not entitled as per the government office memorandum dated 3/10/1969. Lord, this has been come back very late, Lord, on 16th of July 2022. The My lord, parent department, that is the education elementary, my lord, had never objected me regarding, my lord, when I applied for the lien. My lord, my lien application, my lord, may be pleased to find prayer for lien for a period of 3 years, my lord, and a representation was advanced, my lord, is at page 52.
Yes.
Lord, here I have addressed to the Commissioner and Secretary to the Government of Assam Elementary Education Department through proper channel, my lord. Subject prayer for lien. With reference to the subject cited above, I have the honor to state that I have been working as a lecturer in the Diet Karimganj Kaliganj under the Department of the Elementary Education Assam till date. I applied for a faculty post in Medical College under the Department of Health and Family Welfare, Assam, through proper channel, taking departmental NOC, and subsequently I have been appointed for the same post from so and so. In this connection, I am praying for lien for a period of 3 years with effect from 9th of September 2021, which may be extended if needed in future. So I hope you will consider my prayer and approve the lien positively for the purpose of grateful and for this act of kindness, so and so. Now, my lord, this has been again recommended, my lord, forwarded by the, my lord, principal of the Diet College, my lord, wherein I had been working on, my lord, 6/9/2021, the very next page, my lord. And thereafter at page 54, this is to the
So your lien was not considered
my lord, my lien was not considered. That is
because you have less than 3 years of service.
my lord, I
Not
had
confirmed.
no, yes, my lord. That was the ground taken belatedly, my lord. But initially, my lord, when I was working in the Diet, my lord, they have not objected to also, my lord. If my lord may be pleased to find.
So your parent department is?
My lord, director under the Elementary Education Department, this Diet, my lord. That, my lord, I have made the initial prayer for my lien, my lord, is at page number 47. My lord, may kindly have a look, my lord, to issue the NOC to apply for medical social worker. To the Director SCAT Assam, with reference to the subject cited above, I have the honor to state that I am willing to apply for the post of the medical social worker under the community medicine in the different medical colleges under the Health and Family Welfare Department, Assam. In this regard, I need a no objection certificate from your end for the said purpose. Therefore, I request you to consider my prayer and issue a no objection certificate so that it might serve my purpose. And for this act of kindness, so and so, I am not responding to my this application at page 48, annexure 4, my lord. This has been again, my lord, letter has been written by the principal to the commissioner and secretary, my lord. Same thing, my lord, had been reiterated to furnish here with an application of Dr. So and so, establishment seeking NOC to apply for the post of medical social worker under the community medicine, my lord. Accordingly,
Where is that notification of the government?
my lord, that
310,
notification, my lord, office memorandum is at page number 19, page number 67, annexure 19.
67.
Mild. The office memorandum of 1969, my lord, this would mean, my lord, maybe find the government have been considering for some time past the question of protecting the interest of the temporary government servants who go for the better appointment elsewhere on their own application. After considering all aspects of the matter, the governor of Assam is pleased to order that a person who has put in at least 3 years of temporary service in a scheme which is not purely temporary or experimental in nature should be given Wasilian in the post when he takes up the appointment elsewhere as under the so and so are not entitled to get lien. This would mean that if the person wants to return to the same post and that post is still in existence, he should be allowed to join. So if the post is made permanent in the meantime, confirmation should be offered to him even though he is on Wasilian. So, my lord, I came back. This is my, my lord.
You came back, means?
No, my lord, I had applied for, my lord, for returning to my parent department with a request, my lord. After, my lord, my lien period
You applied for lien.
Lien.
And then while the lien was in process, you joined.
My lord.
Then the lien was rejected.
Lien, my lord, the NOC had been given to go for this, my lord, lien, my lord. That NOC is also be a part of my petition, my lord. Is at page 49, issued by the my lord, government in the Education Elementary Department. inviting a reference to your letters on the subject cited above. My lord, this is a letter issued by the additional secretary to the director SCRT. My lord, I am directed to convey that the government of Assam in elementary education department has no objection towards applying for the post of medical social worker, community science or health and family welfare department by the following lecturers of diet. So, my lord, I have constituted, my lord, as that they have not issued NOC, my lord, that I have been given the permission, my lord. And accordingly, by relieving me from the charge also, my lord, I had my debt.
Then after that, what happened?
After that, my lord, I applied responding
After-
to this
after-
advertisement at page 50. my
After
lord.
this page 58,
My lord.
what
my
happened?
lord. After this page 58, my lord. Yes, my lord. After this page 58, now I am still in the, my lord, in the medical department as a MSW worker. Till date, I am working. And this petition was, my lord, filed long back in the 2023. My lord.
Yeah.
And my lord, my instruction is that, my lord, till date the post has not been filled up, still lying vacant in the
In the parent department,
parent department.
you are not allowed to come back.
I am not allowed to come back because of this impugned, my lord, is at page 58, Annex 12. That's why, my lord, I am challenging with the prayer for, my lord, allowing me to come back to my parent department, my lord, with other benefits.
What is the stand of the state?
So the stand of the state is the, my lord, an affidavit has been filed. In paragraph 13, my lord, is at page 89. They have admitted regarding this forwarding of application, my lord, para 13 at page 89, may I read, my lord?
Yes.
That as regard to the amendment made in paragraph 16 of the instant writ petition, the deponent begs to stated in compliance with the government letter number so and so dated so and so, the director of SCRT Assam communicated to the principal diet so and so as regards the granting of lien in respect of the petition. The reply of the letter was furnished by the principal of the said diet on so and so. Accordingly, based on the information furnished by the principal diet Sribhumi, the reply of the government letter furnishing point was information is submitted to the government wide letter so and so dated so and so. Copy of the government letter number dated so and so. That as regards to the amendment made in similar, these are the communications which I have relied, they have again annexed below. That as regards to the amendment made in paragraph number so and so, the deponent reiterate, my lord, there is no any conclusive findings, my lord, that organize the induction of training in paragraph 16 also, my lord. Amendment made in paragraph 19 of the writ petition begs to state that though the office of the director SCRT deponent herein organized the induction training, so and so, but my BN issues has not been, my lord.
What is that OM again?
Yes, my lord, the OM is at page number 67, my lord. May I read again, my lord?
Yes.
Page 67, annexure 19. The government have been considering for some time past the question of protecting the interest of temporary government servants who go for better appointment elsewhere on their own application. After considering all aspects of the matter, the governor of Assam is pleased to order that a person who has put in at least 3 years of temporary service in a scheme, which is not purely temporary or experimental in nature, should be given quasi-lien in the post when he takes up appointment elsewhere. Under the fundamental rules, such government servants are not entitled to get lien. This would mean that if the person wants to return to the same post and that post is still in existence, he should be allowed to join it. If the post is made permanent in the meantime, confirmation should be offered to him even though he is on quasi-lien. This takes effect from the 1st of July 1967, my lord. Now, my lord, in the impugned order,
Yes.
at page, my lord, 58, my lord, they have said that this is not permissible in terms of this, my lord, office memorandum. In inviting a reference to your letter on the subject cited above, I am directed to state that the government of Assam in Elementary Education Department regrets that the proposal for granting of lien in respect of Dr. So-and-so Kaligans cannot be considered due to non-confirmation of her service and her period of service is less than 3 years, which is not entitled as per government notification dated 3/10/1969. What I have understand from this office memorandum, Milord, is not for the, Milord, is very difficult to constitute, Milord, what they want to mean, Milord. This is the reason they have rejected, Milord. And Milord, in fact, I was appointed in a substantive vacant post, Milord, as a lecturer in the Diet, following a due procedure of law, Milord, by of an open selection. Then, Milord, before the, Milord, purpose of, Milord, before my period of 3 years, I did, Milord, admittedly, I did apply, Milord, in the Health Department. My appointment is of 2019, Milord. Annexure 1 in the as a lecturer in the Diet. Then, Milord, after continuing there for a period of, Milord, 2 years, not 2 years, Milord. This is 1/3/7/2019, Milord. So from March to, Milord, July, I was there, Milord. Then I applied for this NOC to go for medical social worker on 3/7/2019. That is there, Milord. That I cannot deny. But this notification has expressly said, Milord, regarding the better appointment elsewhere in their own application, Milord, considering the past question of interest of temporary government servants. Now, Milord, I am not a temporary government servant, Milord. This is the affidavit, Milord. And Milord, when I, Milord, got
Where
this
is
election,
where is your appointment order?
appointment as a Diet lecturer, Milord. Milord, kindly turn to page annexure 1 at page 43, Milord. Is that serial number 6, Milord? Place of posting Karimganj, Milord. This is of 8th of March 2019. Then, Milord, I joined on 11th of March 2019 at page 45, annexure 2. Milord. Then, Milord, I applied for this, Milord, NOC to facilitate me to go for, Milord, this MSW post, Milord, and accordingly I did apply for NOC, which was given. And the advertisement, I was appointed on 4th of September 2021, Milord, as a MSW worker at page 50, annexure 6. Then, Milord, I continue. Then I applied for this lien, Milord, at page 52, annexure 7, Milord, is at 9th of September 2021. Then I join in my new post, Milord, is at page 54. An MSW worker.
Yes. Respondent.
If I'm appearing for SCRT, Lordship. The law is, Lordship, that lien is basically a right to retain the post, Lordship. She was holding earlier, Lordship, if she wants to come back to the post. Now, in this case, Lordship, if Lordship comes to page 45, Lordship, this is a joining letter under Diet Karimganj, Lordship, on 11/3/2019. And at page 47, Lordship, this is a replication. This is dated 3/7/2019, Lordship, for applying for another post, Lordship. This was obviously granted, Lordship. But my friends should understand the difference between NOC for participating in a recruitment and grant of lien, Lordship. If Lordship comes to page 62. Lordship, this is dated 6/9/2021, down below Lordship, 6/9/2021. And this is our application for lien, Lordship. For 3 years with effect from 9 September 2021. Page 62. I mean 52, Lordship. Page 52, this is our application. Dated 6/9/2021 for a period of 3 years with effect from 9 September 2021. But if Lordship comes to page 55, application was on 6 September. On 8th of September, Lordship, she was released. I mean, she left the post. Page 55, 8/9/2021. Certificate of transfer of service. Down below, Lordship, this is the relief officer, Dr. Rasida Begum, Lordship. And if Lordship comes back to page 54, Lordship, this is a joining letter in another department, Lordship. So she left, Diet Karimganj on 8/9. On 9th, Lordship, she joined another department. And all these events took place, Lordship, even before grant of lien or even consideration of a lien application by the authority, Lordship. Now, Lordship, first thing Lordship will notice, she joined the post in 2019. In 2021, she applied for lien. That was not granted. Ultimately, it was rejected, Lordship, in 2022. But the notification, it clearly states, Lordship, for if a person is having less than 3 years of service, she cannot be granted lien, Lordship, for want of confirmation or whatever. Now, Lordship, so far these facts are concerned, SCRT is okay, Lordship. But it was ultimately rejected by the government, Lordship. And I am told, Lordship, government has not yet filed any affidavit, Lordship. So I think if they want, Lordship, they be granted one opportunity to file their affidavit, Lordship. Their affidavit is necessary.
What were you doing when the argument was made? The arguments have been made by the petitioner and now you're praying for 3 weeks' time. You have rejected the grant of lien. On 3/10. Sorry, 16 July. As per an OM dated 1969. 69 says something else.
I will clarify my stand, Lordship, or weeks time may be granted, Lordship.
If you had an intention to make a prayer like this, you should have made it at the before he opened his arguments. Yes, Mr. William.
My lord, my learned additional advocate general, I am grateful to him for educating me, my lord, regarding the NOC and lien. He has just make a submission that NOC, my lord, it is within the district.
The question is whether an affidavit of the
affidavit is required because the impugn order, impugn order is by
the
the, my lord, yes, my lord, by the
the
government.
Council for the Elementary Education during the course of the argument made submits that an affidavit would be required. She prays for 2 weeks' time. Prayer made is not objected to by the Council. Release this matter after 2 weeks on a date to be fixed for the registry. Mr. Nayak, Regional AG, appearing with the state, you have filed an affidavit?
Yes, my affidavit.
Appearing for the representing the finance department, and you filed an affidavit. You can start.
My lord, may I pray for a fixed date? After 15 August.
11th September.
March. Oblige.
That is the loss of profit. Supposed to file IA for implement, annual payment.
Finance department.
You file.
There are
Council
some-
for the petition
The earlier-
and granted 2 weeks time to file application seeking improvement of the finance department. MSP Das for the
Second.
secondary, MS Sharma for accountant.
I'm DPO.
The parties to the provincialization of service of the semester teacher. Recently, the Supreme Court has pronounced some judgment regarding this. I we allow 2 weeks time to file and to produce the judgment by through an affidavit.
So the judgment you don't need to produce by way of an affidavit, you can place it across the board. Like, counsel for the petitioner submits that she would like to rely on certain judgments recently delivered by the apex court, which she prays for 2 weeks time. Mr. U. Sharma appearing to the education department. Released again after 2 weeks.
Met to the lordship. Before my tenure begins, my lord, this matter is dependent on another petition which has been filed, which is coming up for motion today, my lord. It depends on the cancellation of my ST certificate, which they have brought on record by an affidavit, my lord, at page 212. That is coming up for motion now, my lord. Court number 6.
I don't think so, my lord. This is some relation. For a long time it's going on, is listing and listing again.
What is your prayer here?
Prayer for cancellation of the appointment.
Of the petition of the
Selection,
respondent.
anyone is in the selection, exactly. Right. For the post of lecturer in Dibrugarh University. So may I pray, my lord, today your procedure of time already 3:30 is there. So my lord, can it be a fix on 4th, my lord? 4th of August is there.
You are confident that 4th of August you can
4th
take
of
up your
August.
matter before 3:30?
3:30, my lord, because other matters are there. If I start now, my lord, difficult for finish, my lord. Will also reply.
That depends on the court. If we allow you to argue for 1.5 hours, we may not allow you.
At least for both sides, 1 hour will be necessary, my
May
lord.
not be.
Another more for motion also I have to
If
go
you are-
and appear.
if you are not comfortable today, we will accommodate you.
Another case is there,
difficulty.
another case is there, I have to.
Yes, say that. We will accommodate.
That's why, my lord,
The
if I
parties
continue
that,
here,
matter be released on some other date.
4th of August or 6th of August,
6th,
4th or 6th, my lord. For hearing them, my lord, it will be surely, my lord, listed on, my
all
lord,
right, 6th of August.
6th of August. Oblige, my lord.
Yes, Mr. T.D. Nair, senior counsel appearing for the
For respondent number 3.
respondent, the MSP Das for the higher education. Who's for higher education?
It's Assam Agriculture University.
Agriculture University.
Mr. Gogoi appears.
Mr. Guru has been.
D. Mr. D. The Assam Agriculture.
Oblige, my lord.
Deep.
Regarding appointment of arbitrator.
Have you received it?
Declaration has come.
It's come.
Yes.
In deference to the earlier order dated 17/6/2026, Justice D. Biswas, former acting Chief Justice of the Gauhati High Court, as also Justice Siddharth Nidhu, former Chief Justice of the Manipur High Court, has furnished their written declaration, which are available in the records. They have expressed no difficulty in appointing being appointed as an arbitrator. the respective parties and deciding the matter. So accordingly, the appointment of Justice Dinendra Biswas from a judge, former acting Chief Justice of the Gauhati High Court, and Justice Siddharth Mittu, former Chief Justice of the Manipur High Court, have been is confirmed as learned arbitrators for the petitioner and the respondent respectively. So, both the learned arbitrators for the respective parties will now decide and appoint the presiding arbitrator. So, copy of this order be placed before the mark to the respective arbitrators, learned arbitrators by the registry. Parties are also permitted to appear before the respective arbitrators. Once the presiding arbitrator is appointed, the learned arbitrator will proceed in the arbitration. Petition accordingly allowed disposed.
Much obliged. Cases are related to minor body of excess oil after retirement. Objection has been raised by the state respondents manner that after retirement manner, while finalizing the pension, petitioner's lordship has given some undertaking to recover the excess amount which is sought to be recovered. The objection has been raised by the state respondents that the petitioners has given some undertaking to recover the amount while finalizing the pension.
Then
that is why they say that the amount cannot be now returned back. Already they have recovered the amount. Already recovery has been made.
So where is the question of returning it back?
The undertaking they have taken at the time of finalizing the pension, not at the time of fixation. They have to take the undertaking at the time of fixation, not at the time of finalizing the pension. That is not permissible.
What is your prayer exactly here? The writ petition.
I am paying for returning back the recovered amount.
No, is the amount recovered was excess royal?
That is their statement, that this is the amount which was wrongly fixed at the time of while I was in service. By wrong fixation, this amount was paid.
So are you challenging the fixation?
I am not challenging the fixation.
Then?
But finalizing the fixation, I have challenged my lord. The finalizing the fixation of pension, that is under challenge. That is under challenge, but the recovered amount that cannot be permitted to recoverment.
It already been recovered before you come
yes,
to the
yes,
court.
yes, my lord, that is true. But that should be returned back.
How can it be returned back?
Court has already directed.
Provided there is, unless there is a finding that this fixation was incorrect and the amount was wrongly recovered, there can't be a direction to.
That recovery is not permissible after retirement. This will settle my lord.
Recovery is not permissible, but you returned it back. End of story.
But
where is the question of now to say that no, because you have retired, the amount should be returned back without any finding that it was not excess royal.
Undertaking was taken under compulsion. That
all these things are irrelevant now.
Pension was not being
had the amount not been recovered, then something would have been done. Now, unless the court passes an order saying that the fixation of salary is incorrect, and thereby the recovery is not excess royal, but is an amount which is you're legally entitled to. There can be a direction.
In the case, Krishna Court has already, after retirement, when the recovery was made, Krishna Court has directed the authority to return back the amount.
Let us see them.
Paragraph 2 is the facts, my lord. Paragraph 2 is the facts, my lord. Some petition has been filed challenging the action on the part of the responding authorities in deducting an amount of so and so on the ground of so and so ground excess pay and allowances as well as for direction upon the respondent authorities to disperse the same amount already deducted with interest of 12%. That is the facts, my lord.
Yes, respondent, what do you say? Who's for the respondent here? Which department? Secondary education. Yes, scroll.
And laid down in paragraph 1.
Here, this method is allotted to P.com, my lord.
We don't know who it is allotted to. Are we now to ask the council, who is this, are you allotted with this matter?
No, my lord.
This is your internal problem. Where is Mr. Dotto? Here the facts, here the conclusions are different. There is a finding that this is not the fault of the employee concerned.
Yes. Here also, my lord, good
That
fault
is
has
your
been
submission,
attributed.
but we'll have to return a
Well,
finding.
My lord, no fault has been attributed on the petitioner's mind. Only they are saying that man only because of the undertaking that the amount is not permissible. to
Where
be-
is the undertaking?
Undertaking, my lord, they have annexed in their affidavit. One person they have filed affidavit, my lord. Is 95, my lord.
95.
My lord.
Right.
The affidavit filed by the respondents. So 3 has filed that.
95 is the judgment.
Filed by the respondent 3. Next 3.
To arrange the pagination as per this. What is this, Mr. Dotto? What do you say?
Not, my lord. Affidavits are-
No, this undertaking is not to claim for the recovery.
Yes.
The question is, you are now demanding the reimbursement of the amount which you are given it back on the ground that this was wrong fixation. Now, has it been determined that it was incorrect on the part of the respondent to state that it was a wrong fixation of salary?
Submitting whatever amount, whatever the petition was made by the responding authorities itself.
Correct. I have not misrepresented anything to the responsible authority. Is there any finding that this calculation is wrong? One has to arrive at a finding that the calculation is wrong, therefore you are entitled to the reimbursement. That is to be submitted by you because you are the petitioner claiming the reimbursement. You satisfy that the calculation done was wrong. But my last pay drawn is a different amount which they have not considered. And they have considered an amount which was not the last pay drawn amount. You come back prepared. After 1 week. The request of the council for the parties. You come back, make a mention. What is the point fixing dates when you don't want to argue? This is board by order. Matter is listed by order. Do not prepare. Yes, next matter.
May it be pleases your lordship. In this matter, your lordship, instruction received was partial, your lordship. Kindly grant us 2 weeks' time, your lordship, to obtain the up-to-date instruction.
Yes.
Matter is very simple, my lord. This is the area of duty pay in an enhanced rate. And they have submitted the bills also.
They have no instruction. They are praying for time.
Last time 3 weeks. All are retired person.
How much time you want?
2 weeks.
Weeks. Council board parties. MSP Das, standing council, appearing for secondary.
Secondary education.
Reduce the prayer for further time if the instructions are received are not complete. She prays for further time. Prayer made is allowed. He list again after 2 weeks.
Any date.
21st. August.
21st.
Yes.
Deeply obliged.
All right.
Yes. Next week.
It has been listed on account of your lodging order the information.
Yes. Who's for SCRT? The B. Chaudhary. B. Chaudhary, where is Mr. B. Chaudhary? Heard Mr. P. Hazarika for the petitioner and this Kambrai for the Karbi Anglong Council. This Kambrai is basically for set of instructions furnished by the inspector of schools, Karbi Anglong district circle. Wherein it is stated that the certificate of D stop EL stop D in bracket ODL was sent to the director SCERT Assam, Kairipara, for verification for the genuineness regarding the genuineness of the certificate. Stop. The report received stated that the record was not found. Therefore, the monthly salary of the petitioner appears to have been curtailed. Stop. Mr. B. Sharma, stated to be the standing counsel of SCRT, B. Chaudhary, who however is not present when the matter is called up. Accordingly, Mr. Sharma Chaudhary will obtain the required instructions as to the status of the authenticity of this certificate of DLED certificate of the petition and place it before the court the next date fixed. It's on 28th August. You are appearing? So you convey it to him, Mr. A. Chaliha, proxy counsel, on behalf of Mr. B. Chaudhary, will is present and matter be accordingly listed on 28th. Well,
Respondent have filed the affidavit lodging when and declared.
Learned counsel for the petitioner prays for 3 weeks' time. File the rejoinder affidavit. The affidavit filed by the respondent reviewed after 3 weeks. And Mr. S. Huya appears for
Higher 120.
higher education, Mr. S. K. Medi for the CGC. For the accountant. Okay.
Okay.
This month, the petitioner of Bafsi was initially appointed as LDA on 38/11/88. Was appointed as LDA. LDA. He was a graduate at the time of his appointment. On 28/6/1993, government took a policy decision to upgrade the qualified LDAs, the post of assistant teacher, subject to approval of the sub-divisional advisory board. And accordingly, the petitioner was appointed as teacher on 1/1/1996. On 1996. In the meantime, government also took a policy decision. Upgrade was all the graduate incumbents who were working in secondary schools as graduate teachers. Accordingly, the petitioner was upgraded as graduate teacher. Since then, he was working as graduate teacher, and his service was also confirmed as graduate teacher. In the meantime, the respondent number 4, there is a senior dispute between the petitioner and the respondent number 4. He approached the Honorable Court, challenging the seniority of the petitioner. In that case, the Honorable Court has passed an interim order directing the director to take a decision on the seniority of the petitioner as well as the respondent number 4. By the interim order, the director has held that the petitioner is senior to the respondent number 4, as well as just further directed revert back the petitioner to the post of LDA. In your synopsis, what you're saying is something different. That the respondent 4 had filed a writ petition.
Fine.
And the court had remanded the matter to the Director of Secondary Education.
Fine.
Dispose of some representation. Then what happened?
Thereafter, I approached this Honorable Court by filing this writ petition.
Challenging what?
Challenging, in the meantime, the appeal was preferred against the interim order also. Appeal was pending. Well, during pendency of the appeal, the interim order was passed. Interim order was challenged in this petition, and the interim order was stayed by the Honorable Court.
Where is the interim order?
Interim order loss will find at page 40.
40.
Fine.
Where is the order of the court first? WPC 10.
Page,
Page
33.
33.
Fine.
Yes.
That order was put to challenge before the division bench, my lord. That will find the division bench order at page 64. 60.
What happened?
The division bench, my lord, closed the writ appeal, holding that, my lord, closing the writ petition also by further bracketing the interim order, my lord. The case 64, my lord. However, the writ petition being
WBC 6120/2023, that is the present petition minor, is required to be decided by the Learned Single Judge on its own merit without being influenced by the impugn order passed by the Learned Single Judge, which is under challenge in the appeal.
So now the authorities say that your upgradation is contrary to the rules.
My lord, that is, my lord, even if my lord, it is contrary to the rules, it is irregular. It is irregular.
How can it be irregular?
It cannot be illegal, my lord.
What is this?
Because the person.
What is the distinction between irregular and illegal?
Yes, my lord.
Your promotion to the higher post is contrary to the rules. Thereby, you are foreclosing somebody else's
My lord, this is-
chances who otherwise could have been considered in that post.
Now, my lord, I have retired from my service.
You may have retired.
I have retired from my service as teacher, my lord. My pension also, my lord, finalized as teacher. At this stage, my lord, whether the reversion is permissible. Fine.
No. On the day when the order was passed, you were in service.
Yes, sir.
9/10/23.
And it,
So when
it
was the
stayed.
order of reversion passed?
It was stayed by the Supreme Court, man.
This was stayed.
Fine. It was never operated. I worked as teacher. I retired
It
as
has to
teacher.
be refixed.
Not. My lord, but I am submitting. My upgradation was pursuant to policy decision. So kindly see the
Where is
interim
the
order.
policy decision?
I am annexed that. My lord, page 21.
A policy decision. Who takes a policy decision?
Circular, my lord,
What circular?
all the inspector of schools, my lord.
When is the circular? It's contrary to any. There is no decision, there is nothing here. How can it be? How can you claim promotion to another post?
The basis of this circular, my lord, thousands of persons were upgraded as teachers. And that their services.
Which
were-
circular? This 49,
Yes, my lord. Page 21, my lord.
21.
Page 21. There is a three.
How? This is not a circular. This is a circular
Yes, my lord.
to all inspectors.
My lord.
What do you say, respondents?
Lordship, at paragraph 5, we have denied the existence of such circulars, Your Lordship, in my affidavit, Your Lordship. Paragraph 5, page 76, Your Lordship. '76.
76.
Okay.
Yes.
Paragraph 5, Your Lordship. Humbly submits that the reliance placed by the petitioner on an alleged circular dated so and so, on the basis of which the petitioner claims to have been upgraded, the post of assistant teacher is misplaced, untenable inasmuch as no such circular is in existence. It is respectfully submitted that at no point of time did the government take any conscious policy decision to appoint qualified grade 3 or grade 4 employees against the post of assistant teacher on an ad hoc basis, and to subsequently regularize their services on the recommendation of any district level selection board. As such, the purported upgradation order dated so and so issued by the Inspector of Schools, Nalbari, upgrading the petitioner from the post of LDA to assistant teacher is illegal, unauthorized, and wholly without jurisdiction. A bare perusal of the said order dated 1/1/1996 would reveal there is no reference whatsoever to any circular dated 28/6/1993. This is his upgradation order, Your Lordship, or to any government policy on the basis of which such upgradation could have been legally made. Hence, the petitioner's claim founded upon the said alleged circular is false, misleading, and liable to be rejected. Lordship, here I would like to place the rules, Your Lordship. The 1982
Doesn't contemplate any upgradation.
And
It is admitted, madam. Rule does not permit any, contemplate any upgradation. That is admitted.
and Lordship,
But it was the authority who upgraded my service, madam, to a teacher. I was not upgraded myself, madam.
Lordship, then even if you presume that such circular exists, Your Lordship, then that will be dehouse the rules, Your Lordship. That will be illegal, Your Lordship. And any such upgradation will be illegal, Your Lordship. And Lordship, I would also like to place a session of this coordinate bench, Your Lordship. Lordship, paragraph 17, Your Lordship, where the facts are very similar, Your Lordship. Affidavit has been filed by the Director of Secondary Education in so-and-so in the case filed by Sri Sadananda Busha. Stand taken by the Director is that upgradation of the petitioner Sri so-and-so from LDA to assistant teacher was against the suspension vacancy of so-and-so. On reinstatement of so-and-so is to be reverted back to his original post of LDA. Upgradation of so-and-so from LDA to assistant teacher was contrary to rules and therefore his continuance as assistant teacher is illegal. Lordship will come to paragraph 24, Your Lordship. The finding of the Honorable Court, Your Lordship. Under the Assam Secondary Education Service Rules 1982, 24, Your Lordship, paragraph, which was then holding the field, recruitment to the cadre of postgraduate teacher, graduate teacher, and junior teacher was required to be made by direct recruitment only on the basis of advertisement, test, and interview. Method and procedure of recruitment are laid down in Rules 6 and 7. The aforesaid rules do not provide for promotion or upgradation of LDA to the post of assistant teacher. Therefore, upgradation of Sri so-and-so from LDA to assistant teacher is illegal and he cannot continue as assistant teacher. He has to be reverted to his substantive post of LDA. In such circumstances, question of regularizing his service as assistant teacher does not arise. In fact, this is also a stand taken by the Director of Secondary Education, which is the correct position.
The petitioner hearing was upgraded against him on a suspension vacancy. There was no clear vacancy. While the person was reinstated, he claimed upgradation. That circumstances held that this upgradation is not permissible. But in this present case, there is a clear vacancy. It was again upgraded against a clear vacancy.
There has to be a decision by the conscious decision by the state. And this decision cannot be contrary to the rules. The rules don't say so. There is no amendment to the rules.
In the case of Umadevi, paragraph 53.
Umadevi is a case where there were no rules. And there was a decision to regularize, take one-time decision by the government to run a scheme.
Umadevi has been interpreted in Emal Kesari. In Emal Kesari, it has been clarified regarding paragraph 53 that while the appointment is made against a substantive vacant post by the competent authority, but without following the rules, then it is irregular appointment. And if there is no post, appointment is made without following rules, then it is illegal. My appointment is irregular.
No, your appointment strictly cannot be said irregular because you say that there is a policy decision.
Yes,
if the policy decision is correct, then your appointment cannot be irregular.
Even if the policy does, as per their statement,
you have to make your stand clear whether the policy decision is there or not there. If it is there, then you cannot say that it is irregular.
Policy decision was there.
Then why are you resigning
now
from that?
They say that that policy decision is no longer there.
No, they are not saying it is no longer there. They are saying it is not in existence.
But if it is not in existence, then I was upgraded by the authority, but without following the rules.
Yes.
Against a substantive vacant post by the competent authority, then my appointment will be fall under the category of irregular appointment. And by confirming my service,
that is a one-time effect, one-time decision to be taken by the government, not on a case-to-case basis.
By confirming my service, they have already regularized the irregularity. My service has already been confirmed, by order dated 18 January 2001. My service was confirmed along with the other teachers,
Yeah, what do you say?
confirmation, my lord, against the regular
Lordship,
vacant
he was
post.
here, confirmation is date of confirmation is 1/3/89. That is, his confirmation is to the post of LDA, not to the post of assistant teacher. He was upgraded, your lordship. It is some kind of promotion, your lordship. But that upgradation was wrong, your lordship, because LDA cannot be upgraded to the post of assistant teacher. Qualifications will be different, your lordship. And for appointment to graduate teacher, it is always to direct recruitment.
So the confirmation order says the services of the following employees of Korea High Secondary School are hereby confirmed from the date shown against and against post originally created
Originally,
by number so and so,
LDA, your lordship.
permanently retained in so and so.
LDA post.
The post, lordship will kindly see the initial appointment at page 20.
LDA.
LDA is
It can be done.
This is created.
Just see the circular. You have to be maybe appointed on ad hoc basis without selection. And subsequently, their candidates will be placed at the district level for selection and regularization. What kind of a policy decision is that?
Husband, that teacher can be appointed without following rule 8 of the Assam Services Secondary Education Mental Service Rules. The name also, I was when I was in December of Sir S. Chaudhary, I went through that. This case, service has already been confirmed, man. At this stage, on the last occasion, while it was informed to the court that his pension has already been finalized. So, the lordship wanted to see the PTO.
What about the upgradation order?
Okay. This upgradation order, lordship, we have.
You
Because
dispute this upgradation order?
lordship. No, because
Subsequent orders, they have not disputed. Any other, they have not disputed. Only they have disputed the circular.
circular is wrong, your lordship.
Upgradation order. Do you dispute the upgradation order?
Upgradation to the post of assistant teacher, your lordship.
Yes.
Because he was upgraded on the basis of the circular which does not exist, your lordship. So
Dispute the upgradation order.
lordship.
Where is the averment? That this is also a wrong order, non-existent, nothing.
Lordship at page 3, page 76, your lordship. From page 75. Page 75, para 4. While category denying the averments and contentions made in the writ petition, second para, your lordship. It is respectfully submitted that the petitioner was initially appointed as LDA in so-and-so school, while appointment order dated so-and-so. Thereafter, the then inspector of schools, Nalbari, white order dated so-and-so, purportedly upgraded the teacher from the post of LDA to the post of assistant teacher of so-and-so in the pay scale of so-and-so against a vacant post created due to the upgradation of so-and-so to the post of assistant headmaster.
It is respectfully submitted that such upgradation from the post of LDA to assistant teacher was wholly dehorsed the statutory rules, illegal and without any authority of law, as the same was effected without following the prescribed recruitment procedure, including advertisement, selection, or approval of the complaint authority as mandated under the applicable service rules.
Upgradation order, tell us about that.
Ironically, this entire proceeding has been instituted at the behest of the respondent number 4. He was also a product of backdoor entry. He was appointed on ad hoc basis.
Where is the respondent for? You are appearing for respondent.
My position is already decided by security from the submission is that he was upgraded 1996, but the take is graduate scale from 1993 lots. That is page number 23 of IA lots.
IA.
IA is the 243. The number is
44. 244, page 23, serial number 240.
Where is the name of the private respondent?
277.
4?
277. 277.
R4.
First of all, because a commerce based base, without Hindi as a subject, he cannot be appointed as a Hindi teacher. For graduate, for being a graduate Hindi teacher,
So you tell us about the upgradation. What is the status of that? Ultimately, it comes down to the upgradation. Entry or no entry, upgradation, if it is done validly, then is upgraded because and is confirmed from his date of origin posting.
Also, in the impugned order, there we have stated that the upgradation was wrong, and that's why in the impugned order we had asked the inspector of school to revert back the petitioner to the post of an to his original post, your lordship.
Where is the upgradation? And where is the impugned order?
Yes, okay.
Lordship, page 41 is from the second paragraph. On the other hand, Sri Amal Kumar Das was originally appointed as LDA, Karia High School, High Secondary School, plus other allowances.
Upgraded.
In a later date, the inspector of schools, Nalbari, ignoring the government rules and procedures in force at that time, white order dated so-and-so upgraded Sri Amal Kumar Das to the post of assistant teacher.
Getting this Sadananda Bosso judgment.
Lordship, this is the one that I have placed, your lordship.
This one of the appeal against the suspension vacancy. Claim declaration.
This case, your lordship, in Sadananda Bosso at paragraph 23. No, so-called notice was issued to the inspector of schools, your lordship. With the allegation that upgradation of the Sadananda Bosso to the board. This was, here it was issued to the inspector of schools, your lordship. Why such upgradation was made?
Yes. What is this? PPO issue.
My lord. Then get from service, I'm gonna finalize.
Proposal has been sent from the department. So this has been finalized in what scale?
Yeah, my lord, as budget decided.
Have you seen this? Let them find out what proposal they have sent. Come back with instructions. There is this judgment, Sadananda Bushso, there is a conclusion by the coordinate bench that no upgradation is possible under the.
That case, my lord, because reverted back and he claimed for regulation in the upgrade post. In my case, my lord, I was never reverted back. Earlier.
We'll examine but will know the party. The petition runs that he was initially appointed as an LDA. Which school?
Korea High Secondary School.
Huh?
Korea High Secondary School.
Korea.
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 Korea. KARIA.
KA. Korea High Secondary School. Subsequently, he was upgraded to assistant teacher by orders passed by the inspector of schools. His upgradation, however, was challenged by the private respondent. And in which case,
Private respondent never challenged my upgradation. He never challenged my upgradation, whatever. He challenged my seniority.
private respondent was also an LDA.
Lordship, he was a teacher.
Teacher. Private respondent was the teacher, and pursuant to the upgradation of the reputation as an assistant teacher, he was placed higher up the relation list of the private respondent, which sailed by the private respondent by filing WPC number so delegating the matter to the authorities to examine and pass an appropriate order. Huh?
Interim order.
Interim order. But then it was closed in the writ appeal.
In the writ appeal, it was closed.
Ultimately came to be closed and we were delegated department to pass an appropriate order, which order was passed and the department by referring to WPC so and so. That the upgradation, the petition to assistant teacher from LDA was inconsistent with the rules. Therefore, his claim for he wanted regularization. But therefore, he was reverted back to the post of LDA. So, this is safe in the present proceeding. The respondents have filed their affidavits, the state respondents disputing the claim to the petition. Private respondent has also filed an affidavit supporting the case of the respondent, state respondent. So, counsel to the petitioner also submits that a pension proposal has also been finalized and PPO has been issued. And therefore, at this stage, the issued order reverting him back to the post of LDA should be interfered with and set aside, and he should be, having retired, should be allowed to draw his pension as per the PQ issue. Produced a copy of the PQ. The State Council, however, did not have any instructions on the PQ issue. Very made the State Council as to how the proposal of the petitioner was forwarded to the Accountant General Office. The PQ issue Was it in his capacity as an LDA? Was it in respect of his post as LDA or assistant teacher? So this information is not available in the state council. This matter again after 2 weeks for being for hearing. Further hearing.